Actually, he wants to see me
As a judge.
as a judge, as a bigger position than him
Wants
also.
to fulfill his dream through you.
Yes, sir?
Wants to fulfill his dream through you.
I'm so sorry, sir. It is a little bit...
Has to be replaced with the new one.
Because
You can't
the
hear.
background voice is also there.
Once the silence comes, you can hear.
Yes.
Sir, we are not adding one more table. Two tables we are keeping.
Harsh, why can't we bring speaker a little more later? It's looking very far. We can push. Anyway, these good plans are also sitting too far. That's fine, but let podium come.
The court clerks will be there, so
Then they
the
can
speaker
see her properly.
can see the timings.
They have done taping of the wire. They'll have to redo it.
They can push. Not so much. Where table starts, no. At least till there.
Everybody,
Hello. Sir, I am so moved.
Yeah.
Crash.
Right. Bangalore.
Back.
Oh, very nice.
And now, right now, I am in Lhasa. This
Ah.
remains on and works for me.
Okay, no problem.
My call remains on and works for me. Okay.
Right.
Lhasa.
Ah.
kindly be seated.
What a big gathering.
Good afternoon, everyone. On behalf of KLE College of Law, Navi Mumbai, I would like to welcome you all to the final round of Moot Court competition at the 6th Law Festival, Sparkle 6.0. The fixture for the final round of Moot Court competition stands as NMCC 22 representing the petitioner versus NMCC 18 representing the respondent. We seek due permission of the honorable judges to proceed with the rounds.
Yes, of course.
Hello, am I audible?
Yes, yeah.
The council seeks permission to present the arguments on behalf of the petitioner.
Right.
The council humbly seeks the permission to address to the bench as your honor. This is counsel on behalf of Mukul Zaveri and others, presenting the matter of Mukul Zaveri's and others versus Union of Vardhan, in presenting it in the Honorable Supreme Court of Vardhan. The council will be taking 23 minutes, covering issues 1 and 4, which are pertaining to two key provisions of the Surrogacy Regulation Act of 2021, and the other one being exclusion of foreign nationals. And my co-counsel will be arguing on issues 2 and 4, which are pertaining to the discriminatory exclusion of homosexual couples, single intending parents, unmarried couples, and the other one being the unreasonable upper age limit criteria.
Right.
The council seeks permission to present the statement of jurisdiction and facts. The Honorable of Supreme Court of Vardhan has the jurisdiction to hear the present matter under Article 139A, read in reference to Article 132. Sorry, Your Honor, 32, not 132. May I proceed with the statement of facts?
Yes.
In the late 1970s, the assistive reproductive technologies had gained a worldwide popularity. Thus, this caused commercial surrogacy to thrive in the country of Vardhan, earning it the title of the surrogacy capital of the world. However, this unregulated surrogacy had led to exploitative practices, particularly for the economically disadvantaged women. The first guidelines came with the Council of Medical Research's national guidelines, which aimed to regulate infertility clinics. After years of deliberation, the Surrogacy Regulation Act of 2021 was enacted, banning commercial surrogacy and permitting only altruistic surrogacy. It restricted the ART and the surrogacy accesses to married infertile couples and specific women, while prohibiting financial compensation for surrogates beyond medical expenses and insurance. Since the law's enactment, multiple constitutional cases have been filed. Key cases include a case filed by Dr. Mukul Zaveri, who was a former commercial surrogacy practitioner. He had petitioned in the Supreme Court arguing that the ban had led to black market practices and it had also excluded non-traditional cases like his PTSD client Sania. Another such case was where a man wanted to use his dead fiance's frozen egg but was denied to do so only because he was a male. And another such case involved a couple which had narrowly missed the age limit criteria. Now the Supreme Court at Vardhan had overtaken all the cases and scheduled the hearing. May I proceed with
Yes,
issue
yes,
number
please
1?
do, please do.
Your Honor, surrogacy is derived from the Latin word surrogatus, which means substitute. It is a reproductive procedure where a woman carries and delivers the child for another. As defined by this Honorable Supreme Court in the Baby Banji Yamada versus Union of India case, surrogacy, as I would like to officially define it, is a well-known method of reproduction whereby a woman agrees to become pregnant for the purpose of gestating and giving birth to a child she will not raise but hand over to a contracted party. Before I move forward with my arguments, I would like to bring out the difference between altruistic and commercial surrogacy. Altruistic surrogacy is concerned with giving birth to a child only based on selfless idea, just so that she could provide an infertile couple with the greatest gift of a child. Whereas commercial surrogacy includes the same procedure, but the only key difference lies where she is paid for the reproductive services that she is provided. There are, of course, very serious ethical questions whether altruistic and commercial surrogacy can actually be separated. In altruistic surrogacy, they say that she is paid for the medical expenses and the insurance that is incurred during the process of surrogacy. Whereas in commercial, they say that she is paid for the reproductive services that she provides. However, the line is blurred in the payment that merely covers for care or the payment that is paid to be a surrogate. Thus, because intendant's parents seek to exercise control over the lifestyle as well as the activities of the surrogate to ensure a high rate of a successful pregnancy. The equation of commercial surrogacy being in alignment of baby selling is fundamentally very mischaracterizing the true nature of the arrangement. I would like to draw the attention of the bench to the fact that the Ministry of Health and Family Welfare notified the Surrogacy Amendment Rules 2024 to amend the Surrogacy Regulation Rules of 2022 that specifically mentioned that it is necessary that the child to be born must have at least one gamete from the intending couple. And in case either of the intending couples suffer from any medical condition that prevents them from doing so, may use one donor gamete. Thus, also I would like to bring attention to the fact that even in the cases of miscarriage of the baby, the clinic is paid for the service. Thus, this essentially points out the fact that the payment is done for the service and not the end product, which is apparently the child. In a case that the union presents that it should not be a business agreement. Also, secondly, it is noted by Judge Sorkov in the legal case that was the baby M that intending parents already have a genetic tie to the surrogate child. Thus, they cannot be buying a child which is least partly theirs, regardless of any amount of money paid. Now, moving on to the key provisions, key fundamental rights that have been violated by such a ban would be Article 19(1)(g), Article 21, and Article 14. The impugned provisions violate Article 19(1)(g), which protects the right to practice any profession or carry on occupation, trade, or business. The complete prohibition of commercial surrogacy denies surrogate mother fair remuneration for the gestational services and impacts the medical practitioners in the ART industries. This absolute ban on commercial surrogacy does not qualify under the reasonable restriction under Article 19(6). This is said because there has been no sort of reasonable restriction. It has been an absolute ban on commercial surrogacy. In Chintaman Rao versus State of Madhya Pradesh, this court had held that restrictions should not be excessive beyond what is required for public interest. Moving on to Article 21, the impugned provision violate Article 21's guarantee of privacy as well as reproductive autonomy. In B.K. Parsati versus Government of Andhra Pradesh, this court had repetitively held that reproductive rights of any form are a part of right to privacy. As well as in Sujitra Srivastava versus the Chandigarh administration, the court had affirmed that bodily autonomy is integral to the right to life. The ban also violates the right to livelihood of surrogate mothers by banning them from not using this form of surrogacy to maximize their welfare. By prohibiting compensation beyond medical expenses, the law extracts gestational services without any promise of payment beyond medical expenses. As this court has consistently held that depriving someone of their livelihood effectively deprives them of their right to life. Moving on to Article 14. The Act creates a very unreasonable classification by permitting only altruistic to married infertile couples while excluding the rest based on their marital status, sexual orientation, and nationality. This classification lacks intelligible differentia and has no rational nexus with the Act's objective. Because also, I would like to point out how this fails the proportionality test that was established in Modern Dental College versus State of Madhya Pradesh. This test has 4 stages, that is legitimate aim, suitability, necessity, and balancing. Suitability. I would like to begin with the legitimate aim. The council is of the opinion that addressing that exploitation of the mothers that was happening during the unregulation of commercial services is a complete legitimate goal that the state aims to achieve. But we are more concerned with the measures they have taken to address such an exploitation. Suitability. There is no rational nexus between banning commercial surrogacy and preventing the exploitation. Because rather than addressing the exploitation through regulation, this ban has introduced a very paternalistic approach that they're using to undermine a woman's agency and her constitutional rights. Moving on to necessity. Less restrictive measures exist. Proper regulation with safeguard for informed consent, fair compensation, and protection against such exploitation would address the concerns without needing such an absolute ban which would infringe the fundamental rights. Literature on surrogacy mentions that the exploitative nature of the power imbalance between the upper class intending parents and the weaker exploitative surrogate mother is due to the absence on fair consent and the information. Other aspects of surrogacy like the health risk, gender-based exploitation, insufficient compensation, and among other also rightfully elicit concern. However, most of these can be dealt with regulations, and their presence now is not a response for the ban. Balancing. The immediate harm to women's reproductive autonomy and livelihood outweighs the speculative benefits that this ban aims to introduce. Thousands of women are deprived of their income as well as reproductive choices because this is restricted only to married infertile couple. And the connection between these provisions and reducing the exploitation still remains tenacious. Well, the council concedes that reproductive choices of the surrogate mother would have likely had this woman not been poor, because we cannot take this discussion without consideration of the fact that yes, poverty exists in such reasons. But then that does not render the choices of the surrogate mother meaningless. Because we need to recognize that the best of their abilities, they have made such choices to maximize their welfare. And our responsibility is to ensure that they have more choices and more information, and not an absolute ban on surrogacy. The exploitative nature of commercial surrogacy needs to be considered in respect to the other job options available to such women. Suppose we do provide an absolute ban on commercial surrogacy, but the financial desperations which causes them to use commercial surrogacy as a means to livelihood still exist. Then how is this financial desperation not pushing them into a very more invasive methods or forms of job which they can use, like sex trade, prostitution, or human trafficking? What guarantees that they are not being forced into doing this because one aspect of earning their livelihood has been banned? To justify the bans, the harms of the surrogate must be considered with respect to the conditions before surrogacy. Thus, your lordships, I would like to say that the Constitution recognizes substantive equality and not just fair formal equality. The outright ban of commercial surrogacy reflects an antiquated moral position rather than a reasoned approach to prevent exploitation. If the bench is convinced with my argument, may I proceed with issue number 4?
Council, can you?
Please, one or two questions.
Yes, Your
Why
Honor.
you have invoked Article 32? You could have-
Article 32 in the statement of jurisdiction. Just a second, Your Honor.
You could have approached the High Court 226, wider jurisdiction.
Dr. Mukul Zaveri had filed a petition under Article 139A, that was a PIL, and then the Supreme Court had transferred all these cases. Mukul Zaveri, that was the former commercial surrogacy practitioner, had filed this case under Article 32, and then the Supreme Court had overtaken all these cases and transferred it under 139A2.
Okay, Council, what are the fundamental rights that you are arguing for?
The council is of the opinion that majorly Article 19, Article 14 and Article 21 has been violated. We are not concerned with how the exploitation should not be stopped. That is not our aim. The council would like to point out and reiterate that we are more concerned with the measures they have taken to address this exploitation rather when less restrictive measures exist, like a well-regulated system. When altruism can be regulated, why is that an absolute ban on commercial surrogacy has been put? When we can regulate both of them.
See, this stands on a completely different footing. If your contention is basically Article 19 and 21. 21 perhaps it may not come for the reason that right to life perhaps. You see, it's been expanded enough and more now. Article 19, if you want to invoke, it also has some restrictions in several areas. It is not that it is always absolute. And this issue is a very, very sensitive issue. It is not that just any other profession, any other work that you may undertake to earn your livelihood, isn't it?
Yes, Your Honor. Much obliged for the question. I would like I would like to bring the attention of the bench to the fact that surrogacy is, according to the legislation, is only allowed once. Our argument is that when prostitution, according to the case of Buddhadev Karmakar versus Union of India, can be recognized as a profession which uses multiple organs of the body, even if this issue is concerned with organ donation or organ trafficking, if prostitution, which involves so many organs of the body, can be put as a profession, why cannot the reproductive autonomy or the remuneration that a surrogate mother asks for the gestational services she provides not be respected? We are not of the opinion that it should be given free rein. We are of the opinion and we suggest a regulated measure to address the issue of exploitation. I hope that satisfies the bench.
Is right to surrogacy a statutory right or a constitutional right?
Sorry, Your Honor?
The right you are arguing for, right to surrogacy, is a constitutional right or a statutory right?
Your Honor, we are more concerned as to how this ban is violating the reproductive autonomy a woman or a single male or any other person may have. Because everyone has a right to choose the method of reproduction they want to get a baby of their lineage. So that is how we...
What is the nature of that right, madam?
It is not absolute in nature.
No,
The right to
it is a
surrogate.
statutory right under the Act now.
Sorry, Your
It
Honor?
is a statutory right. What you are arguing for is something which is dependent upon the surrogate.
Yes, Your Honor.
and exploitation, or rather commercial exploitation? That is what my brother is asking you.
Your Honor, answering your
What is
question.
the expense of this right?
Expense of
What is the
allowing
expense of this
commercial
right?
surrogacy?
Yes.
According to the statements of object and reason, the ban on commercial surrogacy or the Surrogacy Regulation Act of 2021 was put in response to the exploitation that commercial surrogacy was leading to, because it was unregulated. We merely suggest a well-regulated measure so that this issue, that whether it remains a statutory right.
Maybe we may guide you better. It's all right, good that you are answering. What the honorable member asked you is this. See, there are two types of rights, which one flows from the constitution and one flows from the statutes. Supposing constitutional rights are well defined,
Yes.
right to life, right to livelihood, etc. There are some statutory rights also. Like you see, take for that matter, take Land Reforms Act. So the statute gives the person, a tiller, a right to ask for that land. So
Yes, Your
there is a
Honor.
classic difference between the two. So what he asked is, how do you recognize your right, whether it flows under the constitution or under any statute? That's what was the
A
question.
statutory right, Your Honor.
All right.
May
Good.
I proceed with issue number 4? Issue number 4, that is exclusion of foreign nationals from accessing surrogacies and ART services under Surrogacy Regulation Act of 2021. The Constitution of India, through Article 14, guarantees equality before law to all persons. I would like to focus on all persons within the territory of India and not just merely citizens. This crucial distinction reflects that the framers' intent of the fundamental right and human dignity extend beyond citizenship. The impugned provision creates a very arbitrary and restriction that lacks intelligible differentia by permitting only Indian citizens, non-resident Indians and overseas citizens of India to access surrogacy practices while excluding other foreign nationals. This classification fails the test of reasonable differentia as established in the Honorable Court. Moreover, the arbitrary distinction between NRIs and other foreign nationals lack a very rational nexus with the legislation objectives. If the concern is about commercialization or exploitation, nationality does not seem like a relevant distinguishing factor, because an NRI can easily engage in the same exploitative and commercializing practices than like just another foreign national can. Conversely, a foreign national residing in India may genuinely need the services but may not be permitted to do so only because of his nationality. In the this Honorable Court in Devika Biswas versus Union of India had recognized that the reproductive rights form a very essential part of right to life under Article 21. This encompasses right to access of reproductive healthcare services as well. In the landmark judgment of Justice K.S. Puttaswamy versus Union of India, this court had affirmed that personal decisions regarding family planning and reproduction fall under the protected zone of Article 21. By denying foreign nationals the autonomy to make such intimate life choices, the legislation impermissibly intrudes into a constitutionally protective sphere. Just as I mentioned before, for foreign nationals residing in India, such as diplomats or employees, for example, this exclusion seems a very significant hardship. They may develop medical conditions that require them to use the ART services, but they cannot do so because of this provision. I would also like to point out that even if commercial surrogacy, even if mentioned in cases like the Baby Manji Yamada case versus Union of India and the Jan Balas case, we have seen that exploitation and commercialization was the reason the government gave for banning of foreign nationals. We are not of the intention that foreign nationals are not doing these practices, but even if you are banning commercial services, which was leading to exploitation and payment and citizenship issues, why not approach a less restrictive measures? We already have in the altruistic contract, there needs to be a custody report that comes from the magistrate court that needs to be given before such a procedure can begin. Why not use the same? We can also put a block on the amount of financial or the medical expenses or the insurance that is covered while giving through altruistic surrogacy. Even if the idea is to ban commercialization, why are they also restricted from altruism? If the issue of commercialization or exploitation is the main reason, why not allow altruism as well? The legislation creates illogical scenario that highlights its arbitrary nature. Consider the case given in our submission. An Indian citizen with a foreign spouse was denied access to surrogacy services if they wish to pursue this together, despite one partner being an Indian citizen. This demonstrates that the legislation has failed to take into account such situations that might happen. Furthermore, it creates an unreasonable distinctions between NRIs and other foreign nationals. Both are primarily have their residence outside of India, yet only NRIs are permitted to do so. Your Honor, may I just take a minute to conclude?
All right.
India has developed a world-class facility for surrogacy practices at a very accessible rate that made us the surrogacy capital of the world. This positioned us as a global leader in reproductive medicine. The arbitrary exclusion of foreign nationals not only violates constitutional right, but also undermines India's reputation in global healthcare. Your Lordship, the exclusion of foreign nationals from accessing surrogacy and ART services represents a violation of constitutional guarantees of equality, liberty, and dignity. It creates a very arbitrary classification without rational nexus to the legitimate state interest and imposes a disproportionate restriction on fundamental rights. We pray, therefore, before this honorable court that such a provision must be removed.
Thank you.
I would like to invite my co-counsel to argue
Yes.
further issues.
The council seeks permission to proceed with the arguments. Your Honor, the council would like to contend that restricting access to surrogacy and assisted reproductive technology services to only married heterosexual couples violates Article 14 of the Indian Constitution that guarantees equality before the law and equal protection of the law. Your Honor, by permitting altruistic surrogacy to only heterosexual married couples and disqualifying every other single person based on their marital status, their sexual orientation, and their nationality, this act infringes the right to equality because this is not a reasonable classification and there is no intelligible difference here. The state, in response to the multiple petitions that were filed regarding the surrogacy exclusions, had stated that the welfare of the child is paramount, but they failed to explain why single parents are not for the welfare of the child or why they are deemed harmful to a child's well-being. Your Honor, in a case where the mother dies during childbirth, does the father abandon the child? The father brings up the child as their own. Is this not a single parent giving basic upbringing to the child, and it is not deemed as unharmful as the state says? Your Honor, I would like to give an example, seeking permission to do so. Much obliged, Your Honor. Suppose we consider there is an example of a biological male who wants to transition into a female. This is considered as a trans woman, Your Honor, and I would like to refer to this person as a they. Now the trans person, or the trans woman, wants to have a child before transitioning, and for the very same reason they had frozen their sperm before they started taking the hormones for transitioning and before their gender reassignment. Now, Your Honor, can a trans woman biologically give a child? Can they biologically give birth to a child? No, Your Honor, they do not have the biological capacity because biologically they are a male. But Your Honor, even after transitioning into a female, this trans woman cannot opt for surrogacy merely because they are not married, they are not a widowed or a divorcee woman between the age of 35 to 45. Your Honor, how is this fair? And even if you consider the Supreme Court's judgment in the Nalsa case, they had given transgenders identity rights. And according to the 2019 Transgender Act, these transgender have many rights. So Your Honor, even when the person is considered as a female, they cannot opt for surrogacy merely based on their marital status and because they are not a widow or a divorcee. Now, Your Honor, the council argues that the law is creating a hurdle, especially for transgender rights. Suppose this person does not want to marry. They do not wish to marry, but they do want a child. But according to the law, they cannot opt for surrogacy even if they biologically are not able to get a child because they are not married. Now, Honor, even if we consider the situation that the trans woman is open to marriage, there is huge social stigma surrounding the idea of marrying a transgender. This again, I believe, is propagated by the law. Now, Your Honor, in the case of Shafeen Jahan versus Asokan, the Supreme Court clearly stated that there exists a right to marry as per choice. Now, for a trans woman to get a child, even if it's against her choice, she will have to marry. And if she does not want to stay in that marriage, she has to either be a divorced woman or a widow. And even that has an age limit of 35 to 45. Your Honor, if a woman gets married at 25 and divorced at 26, she will have to wait till the age of 35 to opt for surrogacy, even if she wants a child right now. Your Honor, I would also like to draw the attention of the court to page 20 of the Respondent's Memorial, Your Honor. Page 20. The Council seeks permission to proceed.
Yes.
Your Honor, on page 20 of the Respondent's Memorial, they have stated that the restriction on surrogacy for single parents, LGBTQ individuals, and unmarried couples is based on scientific, psychological, and social factors. So in this, firstly, for the case of intelligible differentia, they have mentioned biological consideration. Your Honor, even in the case of an LGBTQ individual, there is a biological connect because the one single intending parent will donate either their sperm or the egg. So this argument does not stand. The second point they have stated is that emotional stability, studies have shown that children raised in a stable two-parent household perform better on socio-economic parameters. Your Honor, I would firstly like to point out that this was cited from a 1989 convention document. And even if we are taking it into consideration, if this is valid, I would like to contend that a single parent household, how is it not emotionally stable for the child? Your Honor, again, the Surrogacy Regulation Act itself states that a single woman who is widowed or divorced can opt for surrogacy. So this emotional stability, why is it only taken into consideration when it's an LGBTQ individual, or for that matter, a heterosexual individual who's not a widowed or divorced, but is not taken into consideration when it is a woman who's widowed or divorced? Thirdly, they have stated legal certainty, saying that surrogacy contracts often involve legal complications, and ensuring that both parents are married reduces the risk. Your Honor, once again, the very same regulation that they have made this basis on allows divorced or widowed women to opt for surrogacy. So how does this married parents reduces the risk of disputes come into place? Your Honor, the intelligible differentia that is stated by the respondent is invalid. Now secondly, moving on to the rational nexus, they have stated that ensuring child welfare is the primary goal, and it is to secure the best interests of a child, ensuring that they are raised in a stable and structured family environment. Your Honor, I would like to contend that if a single intending parent cannot provide a stable and structured family environment, how is adoption allowed for a single intending parent? Both adoption and surrogacy are not the same, but there is the element of raising the child and upbringing of the child in a stable environment. This argument is once again proven invalid. Secondly, they have stated that preventing commercial exploitation is a rational nexus for restricting surrogacy for single parents. Your Honor, how is commercial exploitation limited to only LGBTQ individuals or heterosexual single parents and not to heterosexual married couples? Commercial exploitation can happen in any case, Your Honor. How is this a basis for restricting who a single parent can opt for surrogacy? And lastly, Your Honor, they have
Counsel,
stated...
you will have to explain that to us.
Your Honor,
You are asking us?
No, Your Honor, the council is trying to say that the basis for rational nexus that is stated by the respondents is invalid because they have allowed a single...
That you please explain. How
Yes,
it
Your
is
Honor,
invalid.
absolutely. As I've stated before, they had stated that structured and stable family environment is necessary, and this they're doing or ensuring by allowing surrogacy for heterosexual married parents for the upbringing of the child to be in a stable environment. But Your Honor, I would like to say that the upbringing of a child happens also in adoption. And the same union, the same government allows adoption to single intending parents. So how is it that the upbringing for a single intending parents when they're adopting a child and the upbringing for a single intending parent when they're going for a child through surrogacy, it is not different, Your Honor. The council would like to contend that the upbringing is the same regardless of how the child is begotten to the parents. The union itself allows adoption but restricts surrogacy. And lastly, they have stated that surrogacy would impact public morality. The council would like to contend that morality is very dynamic in nature, Your Honor.
Counsel, your contention should be based upon certain evidence justification.
Yes, Your Honor. I have mentioned, as
You
I've
are
mentioned,
merely stating your opinion.
Your Honor, as I've mentioned before, the Adoption Regulations 2022 or the CARA guidelines clearly state that a single intending parent can adopt a child below 2 years of age till 85 cumulative years old and 40 single age years old. But surrogacy is not available to single intending parents. It is a legislative act that allows single intending parents to adopt but not to opt for surrogacy. My whole basis...
There is one basic fundamental flaw, if you may say so, in this argument. How does law get enacted? You must go to the root of the matter. So, the bill is presented.
Yes, Your Honor.
It is debated in the parliament, in 2 houses of the parliament. If it requires the approval of, if it's a major bill, if it requires the approval of the assemblies, it will go around to all assemblies.
Absolutely, Your
And then
Honor.
it will come back. So that means what? The law of the land is the wish of the people which gets translated into an act or which becomes a law. The points that you have raised, which the honorable member pointed out to you, that you see you are raising questions with regard to this act that must have a historical evidence and a point saying that this is completely contrary to either to the constitution or the power of the parliament to enact this law. There are only 2 basic concepts that you will have to examine and then put it across to the bench. You are bringing it for the benefit of the exceptions. What the parliament has thought it fit is for the benefit of the nation as such. So you must have an absolute clarity on that and then show that this is ultra vires for this reason. That's what he just pointed out.
Much obliged, Your Honor. The council wholeheartedly accepts and understands the point that the honorable bench makes, and would also like to add on to the fact that the reasoning I have stated for the invalidity of the rational nexus and intelligible differentia is supported by previous Supreme Court judgments as well as the Adoption Regulation Act. I would also like to point out that morality changes over time, and as the society moves on, so should the law. And I also do believe that right now the law can severely impact the social stigma that surrounds around transgender individuals or LGBTQ individuals. Law and society should be hand in hand, Your Honor, and I believe that even a change in one would lead to a detrimental and a very important change in the other. So if the law allows for single intending parents...
There again. Now this is the latest law that has been enacted. So the parliament has thought about it and brought in a law. Please tell us that to strike it down, what are the main parameters?
Your Honor, the council does not want to strike down the entire law that the parliament
Read it down.
has.
Either you can strike it down or read it down.
The council merely contends for a few changes in the restrictions that have been placed on certain individuals in the country whose basis that the council believes to be arbitrary in nature, Your Honor.
Okay, counsel, you may believe, you may feel, you may guess. That is not the function of the court. Function of the court is not to test what you believe, what you guess, what you understand. The function of the court is to ascertain the law.
Yes, Your Honor.
You have taken a set of facts, but your application to the law, application of the law to the facts is not clear to us. You keep on saying that you believe. You believe it is your belief.
Much obliged, Your Honor.
Yes, and one more thing, who has enacted this law? The parliament.
Yes, Your Honor.
What was before the parliament? The 228th Law Commission report, which is part of your Moot proposition.
Yes, Your Honor.
It was debated,
Yes, Your Honor.
it was understood. What you are arguing is against a tenet which is stated in the Law Commission report, which has been wholeheartedly unanimously accepted by the Parliament, and the law has been enacted. Now, if you want to read it down, your belief and opinion would not matter, rather than something to convince the court that the law which has been enacted has caused detriment, has caused some nuisance, because of which it needs to be read down. What is that? That is what you are not showing. Under the garb of commercial surrogacy being banned, you are trying to argue these points on morality, which probably may not make any dent with the court.
Your Honor, the Council would like to firstly apologize for the confusion caused for the use of the word belief. The Council contends and argues on these points, which the Council also has given backing by Supreme Court judgments, certain cases, and certain other legislation such as the CARA guidelines and the adoption regulations.
What does it say?
Your Honor, as I've stated before, the Adoption Regulations Act 2022 and the CARA guidelines have clearly stated that a single intending parent can opt for adoption of a child below the age of 2. Your Honor, according to the respondents, the rational nexus behind not allowing single intending parents to go for surrogacy is that they're ensuring that they're raised in a stable and structured family environment. The Council would like to argue that the upbringing and the structured, stable environment applies in both the cases of adoption and surrogacy, Your Honor, because it is regarding the context of bringing up a child. I do not equate surrogacy and adoption, Your Honor. The Council is merely stating that the upbringing of a child is the same regardless of which method the child is brought into this world, and if the legislature is allowing a single intending parent to raise a child and acknowledging that they can give a stable upbringing to the child under adoption, they should do the same for surrogacy. They should not have a different opinion or a different approach regarding the upbringing of a child for surrogacy and adoption, Your Honor. This is the point that the Council was trying to make.
Right.
Thank you, Your Honor. The Council would also like to state that the law is perpetuating a social stigma against LGBTQ individuals, and in the garb of maintaining family structure, it is taking away the right of both heterosexual single intending parents as well as LGBTQ single intending parents. If the law is allowing single intending parents for adoption, it should do the same for surrogacy, because their main basis for not allowing is the upbringing of a child, which is the same for adoption and surrogacy. The Council would like to proceed with issue number 3, Your Honor.
Right.
The Council argues that the right of a couple to avail surrogacy being restricted to married couples between the age of 22 to 50 in case of female and 26 to 55 in case of male is not constitutional and violative of Article 14 and Article 21 of the Constitution of India, and causes severe mental strain on parents who want to opt for assisted reproductive techniques. Your Honor, assuming and generalizing that everybody above a certain age cannot bring up a child and not taking into consideration an individual's health, an individual's capacity, and an individual's medical suitability is impractical and disregards the choice of a citizen, Your Honor. Your Honor, considering the genetic makeup, a decrease in sperm quality over the years is a major concern as to why surrogacy is not allowed at a certain age. But Your Honor, technological advancements in the medical field, particularly for assisted reproductive technology, and the clinics are enabled to detect potential issues early and make informed decisions about the success rates of surrogacy, Your Honor. Furthermore, there also is the available technology of cryopreservation, which is the freezing of eggs or sperms. Now, Honor, if we go beyond the technological development and giving birth of a child, it is important to recognize that older parents may have more financial stability and they potentially are capable of providing stability and good upbringing for the children. Your Honor, I would like to draw the attention of the court to the case of H. Siddharaju versus the Union of India. In the said case, Your Honor, the petitioner, one of the petitioner or the husband was 57 years old, and the wife, the second petitioner, was a 45-year-old woman. Your Honor, according to the Surrogacy Regulation Act, the husband loses eligibility to opt for surrogacy, but the woman still has eligibility to opt for surrogacy. So according to the regulation, the couple cannot opt for surrogacy merely because one spouse of the couple is not eligible. Your Honor, in this case, the court had stated 3 satisfactory determining tests, Your Honor. It is the genetic test, the physical test, and the economical test. The court had proposed these tests and stated that if the male petitioner or the husband who is beyond the age thresholds satisfactorily convinces and passes these tests, the physical, genetic, and economic tests, he can be allowed to opt for surrogacy. The council would like to argue that this is a valid measure that can be implemented by the state in certain cases where one person of the couple or both the couple go beyond the age threshold, Your Honor. Your Honor, the foundational argument that is behind the unconstitutionality of the age limit is the restriction to personal choice. Every citizen of India has the right to personal choice, and reproductive rights come under this right. Your Honor, while referencing to Article 16(1) of the Universal Declaration of Human Rights, it is stated that men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry and to find a family. They are entitled to equal rights as to marriage, during marriage, and its dissolution. It is detrimental that if a couple is capable and willing to raise a child, they should not be barred on such an archaic basis. Your Honor, the council would once again like to clarify. We are not against the age threshold as a whole. We do agree that there are certain medical, physical, and psychological factors that come into play once the male or a female in a couple goes beyond the age. But we would also like to emphasize that an entire ban on such a big nation like India, where there may be many cases or multiple cases where one person is above the age threshold and they want to opt for surrogacy, they should go through some few tests, genetic, physical, economical, psychological, to determine if they are capable of raising a child or not. A complete ban on anybody above a certain age is restrictive, Your Honor, and the council argues against that.
Thank you.
The council would like to proceed with the prayer, Your Honor.
Yes.
Wherefore, in the lights of the facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed before the Honorable Supreme Court to be graciously pleased to declare that prohibition of commercial surrogacy as stated under Section 42B and Section 42C of the Surrogacy Regulation Act 2021 is unconstitutional. Declare that restricting access to surrogacy and ART services to only married heterosexual couples violates the fundamental right to equality by excluding single intending parents, LGBTQ individuals, and unmarried couples without a reasonable classification. Declare that the exclusion of foreign nationals from accessing surrogacy and ART services under the Surrogacy Regulation Act and the Assisted Reproductive Technology Act violates the fundamental rights guaranteed under the Constitution. Declare that the right of a couple to avail surrogacy being restricted to married couples between the age of 23 and 50 years in case of females and 26 and 55 years in case of males, as it is being provided as stated under Section 42C, read with Section 21H of the Surrogacy Regulation Act, is unconstitutional, and pass any other order the Honorable Supreme Court may deem fit in the interest of justice, equity, and good conscience.
Thank you.
Thank you, Your Honor.
Yes. Yes. Right.
The council seek permission to start. Is the void modulation clear? This is the council appearing in the case of Dr. Mukul Zaveri versus the Union of Vardhan on the behalf of respondent. If your lordships has no inconvenience, may the council refer the bench as your lordships. Much obliged. If your lordships are well versed with the facts of the case, may the council starts with the arguments advanced. Much obliged. The first and the third argument will be dealt by me, and the second and the fourth argument will be dealt by my co-counsel. The first argument that has been put forth before this honorable bench is whether restriction upon regulation of 4 clause 2 clause B and 4 clause 2 clause C, where commercial surrogacy has been blanket ban, is constitutional or not. Your lordships, the council on behalf of the respondent will humbly submit that the blanket ban was well within the limits of the state power to legislate and thus does not violate the fundamental rights of the petitioner and is in verse with the Article 14, Article 21 and Article 19 of the Constitution. Further, your lordship, it is well versed with the international standards and international conventions that Vardhan is signatory to. Your lordships, the council will be justifying...
Council, we have heard that. Can you please explain a socio-economic dimension of this law?
Your lordship, from the perspective of socio-economic dimension, it has to be taken into consideration that surrogacy is not a source of livelihood. Your lordship, livelihood is something that is performed again and again. Here, surrogacy cannot be performed again and again. It cannot be looked upon as a source of profession. Your lordship, Article 19 comes with certain reasonable restrictions. As it has been mentioned under Article 19 Clause 6, as it has been mentioned under Article 19 Clause 6, it cannot be seen as an absolute right. Your lordship, further keeping it in consonance with the act of transplantation of human organs and tissues as your kind.
Both the sides have been arguing it is an absolute right. For that matter, no right is absolute.
If your lordships may repeat. Your lordship, it has to be taken into consideration that the objective of the act is to prevent that the organs and the tissues are not being sold. It is being donated. Here, what the respondent has done is the same. It has drawn a distinction between commercial surrogacy and altruistic surrogacy. The necessity has yet been kept into mind that the right of parenthood of individual is not been infringed. Your lordship, altruistic surrogacy arises with the sole motive and intent of love and compassion, whereas commercial surrogacy arises with the motive of financial gains. Your lordship, it has to be taken into consideration that the part of a human body could not be sold. Here, the objective of the act, as your lordships may refer to page number 3 of the compendium. Under page number 3 of the compendium, in the judgment of State of West Bengal versus Anwar Ali, it was held that any act which draws a classification has to pass a two-pronged test, as it has been stated in Article 14 of the Constitution. The two-pronged test states that the intelligible differentia and the rational nexus. Intelligible differentia refers that the difference that has been drawn has to be in consonance with the objective, and there should be a direct nexus with the objective that has to be achieved. Further, your lordship, the difference that has been drawn is between altruistic surrogacy and commercial surrogacy. The surrogacy as a whole has not been banned. Altruistic surrogacy arises with the sole motive of love and compassion, whereas commercial surrogacy arises with the motive of financial gains. And here it has to be drawn that if altruistic surrogacy is adopted, the practices like womb on rent, baby selling will be restricted. If your lordship permit, may I move forward?
See, now you referred to Article 14.
Indeed.
So in Article 14 aspect, if you consider the advocates for the petitioners, they argued that there is an age restriction so far as between which two ages that they can seek for surrogation, isn't it? So an example was given that if a person was married at 24 and got divorced at 26, so you can still not consider or accept this surrogation.
Indeed, your lordship.
Therefore, to that extent, to a small extent, you see, you may have a kind of a violation of their right or discrimination, at least in the least. How do you see this?
If your lordship, I'm correct, the question what has been put forth by the bench is that the short term of the marriage has to be taken into consideration.
See, as far as the surrogation is concerned, some age limits have been given, isn't it?
Indeed.
So that age limit starts from 35.
Your lordship,
That's what was argued between the age of 35 and 55. Is that right?
Your lordship, it has to be taken into consideration that the age limit is 26 to 55 for males and 21 to 50 for females.
So if we understood correctly, what the petitioners were contending is there was some small age group difference was there. To that extent, it may not be so much, it may not be overlapping either. But there could be a chance, there could be a reason that you see it may not be fully an act may not be struck down, but small corrections may be required in this.
Indeed, your lordship, if your lordship's contention is
What my brother is asking, why 55? Why 50? If somebody is 51, will that woman not be entitled?
indeed, your lordship,
Otherwise, she is capable.
the legislative intent behind setting up an advanced age limit was because of the advanced parental age. Your lordship, the act first of all is in well consonance with the CARA regulations, as your petitioners mentioned. Under CARA regulations, it can be clearly seen that the adoptive parentage age should be 95 for adopting a child that is below 2 years. Here, here the minimum age of both the couples will be under 50 and 55. Further, it has to be taken into consideration that in terms of surrogacy, the genetic ability of the individual decreases. Here, it will be leading to infertility of the child, infirmity of the child. As your lordship may refer to page number 260, sorry. As your lordship may refer to page number 146 of the compendium. Six of the compendium.
Yes.
Are your lordships with me? Indeed. As your lordship will see, it was a study conducted where it was stated that the sex chromosome aneuploidy of an individual decreases with the growing age. At coming by the age of 40, it decreases by 51 per 10,000. And your lordship, it has to be taken into consideration that as these genetic ability of an individual decreases, it lead to infirmity of the child. Here, it has to be taken into consideration that the best interest of the child has been kept forward. While considering the age of 51 and 55, it has been harmonized with the rights of the intending parents. Here, we have taken that child's rights are not being infringed while protecting the rights of the parent, and parents' rights are not being infringed while protecting the rights of a child, thus leading to principle of harmonization. If your lordship permits, may I continue with my issues further? Indeed. Your lordship, further it has to be taken into consideration Article 21, which guarantees every individual the right to life and personal liberty. Further, as it can be held in judgment of K.S. Puttaswamy of this honorable bench, that right to privacy and personal liberty is not just restricted to from physical restraint. It extends to one's life and body. In the case of B.K. Parthasarthi and in the case of Suchita Srivastava, it was held that a personal autonomy of reproductive autonomy of an individual is a facet of right to privacy. Thus, right to reproductive autonomy is directly tied to Article 21 of the Constitution. Further, it has to be taken into consideration that reproductive autonomy here refers that the person has the right to take a decision about its reproduction. Here, if we take into consideration, they were being coerced, they were being, due to their financial restraint, they were undergoing surrogacy, and thus it created a structural exploitation of them. Your lordship, it has been taken into consideration that middle pathway has not been adopted just with the same reason. Further, it has to be taken into consideration that whenever there is a restriction upon Article 21 of the Constitution, it has to surpass the test of proportionality. The proportionality, as it was held in the judgment of K.S. Puttaswamy, it passes through three pronged tests. First, the legitimate aim of the legislation. Second, the necessity that is being put forth, and third, the benefit that is arising from the imposed legislation outweighs the harm that it was causing. As your lordship, the legitimate aim is well in consonance with the constitution. It protects the women, the surrogate women, from being exploited, commodification of the surrogate women. It protects the surrogate child and also the rights of the intending parents. Further, considering the concept of necessity, your lordship, it has to be taken into consideration, surrogacy as a whole has not been banned. Only commercial surrogacy has been banned, and in consonance with 4(2) clause B of the following act, altruistic surrogacy has been allowed. Your lordship, we may refer to the select committee report that was that passes through when a legislation passes through Lok Sabha to Rajya Sabha. It was established during that phase, the select committee, which consisted of several judges and professionals for the following surrogacy practitioners. It was the commission comes to a conclusion, as may refer to 274 of the select committee of the compendium select committee report. It was concluded that compensatory surrogacy could not be given to the petitioners on the sole basis as we cannot put a price tag upon the practice of surrogacy. If compensatory surrogacy is awarded, here compensatory surrogacy refers that certain amount of compensation will be given to the surrogate mothers, and here it will reduce the chance of bargaining and thus no exploitation. But it has to be taken into consideration that we cannot put a price tag on the reproductive function of a woman. Further, it has to be taken into consideration that the legislation is being backed up by certain select committee reports of 288 select committee report, as it may be seen on page 269 of the compendium, where it was said that a pragmatic approach has to be adopted. Pragmatic approach, keeping in mind that both rights, all the rights of all the stakeholders are being protected, and commercial surrogacy should be banned. Further, your lordship, it has also been taken into consideration that in judgments like Jan Bilas and Baby Manji, as my learned petitioner has clearly mentioned, it was not, commercial surrogacy was not recognized, it was not legalized. It was held that yes, commercial surrogacy exists, and it is the duty of the legislature to put certain regulations upon it so that exploitation that was presently occurring at that time does not continue. Further, your lordship, if your lordship permits, may I move my third
Yes.
There
Yes.
is one question, Council.
Indeed.
How this law is going to affect inheritance and succession?
Your lordship, inheritance and succession in terms of if a surrogate child is born, how that affects your lordship, it has to be taken into consideration that when a surrogate child has been born, the surrogate child will get the rights same as those of the rights of a natural born. Thus, the Succession and Inheritance Act will act upon the surrogate child same as that of a natural birth child.
Is it stated in law?
Your lordships? If your lordships may repeat the question.
What you said is stated in law.
Indeed, your lordship. As your lordship may refer to the section 8 of the act, it is mentioned that the child that is born to surrogacy will be treated same as the child that is born through natural means of procreation.
Right.
If your lordships are satisfied with my contentions, may I move to the third issue? Much obliged. The third issue that has been put forth before this honorable court is whether the age restriction that has been set up for an intending parent to adopt surrogacy is constitutional or not, or whether it violates the fundamental rights of an individual. Your lordship, the council humbly submits before this honorable court that the age limit that has been set up is well versed with the scientific approach, is kept in mind that the rights of a child is not being infringed and the rights of the intending parents are not being infringed, and is in consonance with the previous precedents of the honorable court and the lower courts. Your lordship, I will be justifying my statement in a twofold manner. First, how it does not infringe the fundamental rights. Article 14 has to be taken into consideration again, where two-class differentiation has been drawn of legitimate differentia and the nexus that it draws with the objective of the act. It has to be taken into consideration that the objective of the act is to protect the rights of the surrogate child. If your lordship, if we consider the contention of the petitioner, where they argued that a three-pronged test that was established in the H. Siddharaju case of the Honorable Court of Karnataka, it was, although it was not laid down by the Honorable Court, it was just a suggestion that was being put forth before this Honorable Court. As your lordship may refer to the order of that particular judgment, it was clearly mentioned that this is the matter is being listed before this apex court, and it is not within the limits of this Honorable Court to adjudicate upon this matter. Further, your lordship, it was also contended that when we consider the genetic ability of an individual, the genetic ability of an individual decreases with time, and at an advanced age, if surrogacy is allowed to be availed, it will lead to infringement of the very fundamental right of an unborn child. Further, it has to be taken into consideration the physical test. As your lordship, the petitioners mentioned, with time and advanced age, after, for an example, after reaching a certain age of 15, the parents might be at certain age of 70s. Here, it might lead to a state of parentless of an individual child. It has to be taken into consideration that when a child is born, when a child comes into picture and not in the initial state, the maintenance has to be taken. Here, the parenthood has to be considered for a long period. At a certain age, the child needs to get the love and affection of the following parents. And after reaching a certain age, it is not possible physically for a parent to give the same amount of love and compassion to the child. Further, your lordship, it was also considered in the judgment of Jesse Co. versus Union of India in the state of adoption. It was considered that it is not the powers of the court to legislate upon certain restrictions that are being imposed, keeping in mind the scientific nature of the criteria that has been put forth before the legislation. The question that was being put forth before the court was whether the adoptive age that has been put forth under CARA Regulation 5 is well versed in consonance with the adoption age.
One question, how would you justify and defend the single parenthood ban which is imposed by this regulation?
Indeed, your lordship.
So that is also a part of your issue number 3, which you have not argued.
Your lordship, the issue number Your lordship, the question that has been put forth before by the honorable bench is whether a single parenthood should be allowed or not. That question has been dealt in detail by my co-counsel in issue number 2, which ensures that why only married couples were allowed to avail surrogacy and why there has been a distinction on the basis of marriage.
Take a case, for example, if one of the parent expires.
Indeed.
And the child is required to be brought up by a single parent, then what would be the difference in that case?
Indeed. Your lordship, here it has to be taken into consideration that the parent expired when the child was brought into the world. Here, it was not in the powers of a human to control over it. But in terms of surrogacy, the child is being brought into the world with the sole motive that he will be giving love and compassion of only a single parent.
In both cases, the welfare and paramount consideration is the welfare of the child.
Indeed, your lordship.
After he comes into this world. So in the case of surrogacy, he would come at the wish of the parents. In the case of a general case, if one of the parent dies and only a single parent has to bring up the child for the rest of his life, would the situations not have a parallel or similarity?
Your lordship, indeed.
Then why the ban on the single parenthood?
Your lordship, it has to be taken into consideration that when we talk about single parenthood and the parents, if your lordship permits, may I answer the question?
Ask your co-person who is going to argue on this too.
Indeed, Your Lordship. If Your Lordship permits, may my co-counsel deal with issue number 2 and 4?
Right.
Much obliged.
Correct, correct. It is only that how they prepare the case, how they come. That's the
Answering the question
Yes,
of the
it is
judges is
difficult.
very important.
Please.
Your Lordship, this is a Hello, am I audible, Your Lordship?
Yes, yes.
Lordship, this is a counsel number 2 for the side of the respondents. First of all, Your Lordship, with the permission of the bench, may I answer the question that was posed to my co-counsel? Much
Yes.
obliged, Your Lordship. Your Lordship, as much the question that was understood by the counsel was that why there's a clear clause wherein an individual, if for an example, if an individual, a couple, one of the couple dies, then the same case will be happening if it's a single intending parent. Indeed, Your Lordships. Answering the question is a very simple answer that the principle of natural destiny comes into the picture. The principle of natural destiny states that the state cannot do something which is affecting the natural destiny. For example, Your Lordship, what happens with a person who dies is through natural means. But when a state is coming with a legislation, you cannot have a legislation in such a manner that is affecting the natural destiny of the particular act. If one of the couple dies, then it is because of the nature. But if we, as a state, as the union of this country, if we bring a legislation which is for the purpose that even the immediate intention of bringing that child is without a particular right to parenthood. Because your Lordship, there are 3 rights which is particularly provided to a child. First 3 rights. Right to parenthood, right to life, and lastly, right to find a family. All the 3 rights are particular in nature and from which 2 rights are taken. Your Lordship, right to parenthood, because one of the right of parenthood is having both the parents, that is male and a female. Right of parenthood is been taken, and lastly, right to find a family. Right to finding a family also includes family of natural legitimate basis. Natural legitimate family includes of 3 individuals, that is a child, a father and a mother. So this is what
Okay, counsel, what is natural legitimate family under which law you have stated?
Indeed, Lordship, there is no clear-cut definition of natural legitimate family, but there are numerous cases where it has.
Please quote them.
Indeed, Your Lordships. For the convenience of the bench, I should quote the case of Indra Sharma versus V.K. Sharma. The case has been quoted.
What was the issue in that case?
Your Lordship, the case had a issue of marital status, wherein the legal stability of a marriage was taken into consideration, wherein it was the the case has been mentioned on page number 143 to 145 of the compendium of the respondents. Your Lordship, in that particular case, the Supreme Court quoted that marriage provides a legal stability, a social recognition, and a clear framework of parental responsibility. Your Lordship, 3 important things were taken into consideration. That was a legal stability, a social recognition, and lastly, a clear framework of parental responsibility.
Natural legitimate family.
Your Lordship, this was the particular case wherein a legitimate family, a legal structure of a family was taken into consideration, and that has been quoted by the council as a natural legitimate family.
No, we are not interested in that. We would like to know what is natural legitimate family.
A natural legitimate family consists.
It is natural.
Indeed, it's
Then
natural.
it becomes legitimate.
Indeed, Your Lordships. Your Lordships, a natural legitimate family includes of 3 individuals, that is a child, a father, and a mother. Because love and affection has to be provided by both the parents, that is a father and a mother. A love of a mother cannot be provided by the father, and a love of the father cannot be provided by a mother. And that is the reason it has been concluded by the council as a natural legitimate family. If the Lordships are satisfied with that particular argument, may I continue with my issues?
Yes.
Much obliged, Your Lordships. Your Lordship, the Council will be dealing with the second and the fourth issue. The second issue being whether restricting access to surrogacy and ART services to only married heterosexual couples violate the fundamental right to equality by excluding single intending parents, LGBTQ individuals, and unmarried couples without reasonable classification. Your Lordship, we have taken into consideration many more aspects when we have now derived upon the fact that we have reasonably classified few individuals, few groups of identifiers from that particular act. Your Lordship, delving upon the particular topic, starting with Article 14 that was quoted by the learned Moot, they have put upon the concerns that we have not given reasonable classification and intelligible differentia that was taken by intelligible differentia and rational nexus that was taken by us. Firstly, quoting the petitioner's argument on the page number 20 of the respondents, wherein the intelligible differentia has been quoted by the respondent, is that we have taken three grounds into consideration. One, biological consideration. Second, emotional stability. And third, legal certainty. Your Lordships, when biological consideration is taken into was taken into effect, we have mentioned a child's genetic and medical history is best documented in a biologically connected. Your Lordship, this was quoted by the learned petitioner council, but they didn't quote. And legally recognized family structure was also quoted in the same case of Air India versus Nargesh Mirza, which is mentioned in page number 126, wherein the court itself stated that legally recognized family structures in India, only legally recognized family structure is having a mother, a father, and a child. And the same thing has done by the state, by the union of this country, Union of Vardhan. Your Lordship, now moving on the rational nexus. Emotional child welfare was taken into consideration by us because having parents, when we talk about having parents, and the learned mate talked about CARA regulations, and even the Lordships taken into consideration that why, on what grounds, an individual is allowed to have adoption, but on the other hand, a particular couple, a particular individual is not allowed to have surrogacy. Your Lordship, when it comes to adoption, that particular child has lost the basic right of parenthood naturally. Now that child doesn't have any parent. So now it becomes a responsibility of the child to give some particular rights to that child. Then that particular rights cannot be absolute. That particular rights includes at least giving a single parent to that particular child. That comes in adoption, and that has been defined by the CARA regulations. And now, more importantly, when it comes to surrogacy, Your Lordship, the state cannot have an intention that immediately the child comes into effect. On that particular intentional basis, we are taking the right of that child to have just single parent. Your Lordship, that person has to have both, that child has to have both parents. A single parent cannot and should not be given that particular right to take the care of the child. Your Lordship, this was with regards to the exclusion that was made by the state from the side of, on the basis of marriage. This was a question posed by the co-counsel. Probably they would have got the answers with regards to that. And probably, Your Lordship, moving forward, the reason why we have not included LGBTQ individuals, we have not even allowed a single father and a divorced father and a widowed father, male, from the particular sections of the Act. The reason for is very much simple. That can be seen in the CARA regulations as well. Your Lordship, in the CARA regulations, a single male is not allowed to adopt a female. Your Lordship, the reason behind this, that whenever a father adopts a female, there is probably a chance of exploitation. And we have also taken this into consideration. Even the select committee, when brought into the picture, the particular individual, I'll name that particular person, Suchita Srivastav, Dr. Suchita Srivastav, she immediately quoted upon this point that we should not be given a particular male individual the right to surrogacy if he is single, is because that what if exploitation occurs? Because in surrogacy, there cannot be a particular criteria that only a female will be coming on the birth, only a male will be coming on the birth. So, if there is no guarantee that whether the female is going to come on birth, whether a male child will be coming on birth, and taking that into consideration, the state taking the select committee report into consideration, we made a law wherein we have not allowed a widowed man and a divorced man under the criteria of the particular act. Now lastly, moving to the LGBTQ individuals, the learned petitioner quoted upon this point that why we have not included transgender, the trans women and transgenders, the LGBTQ individuals under particular act. With regards to LGBTQ individuals, we have not taken into consideration on the same ground of single parents. With regards to transgenders, right to marriage to the transgender was recognized in the case of Supreme in the 2023 and in Nalsa versus Union of India as well. Your Lordship, they have given the right to marriage, but they are yet not provided the right to surrogacy. The reason for this is very much simple, because they cannot have a heterosexual, their marriage cannot be considered as heterosexual, and they themselves through natural means cannot have procreation. If we go upon the statements and objects of the particular act, it has been clearly stated by the legislation themselves that when we bring this act into consideration, we are enabling this particular act, we are providing this particular act to only those couples who have, through natural means, failed to achieve the procreation services. Natural means procreation services is through sexual means. Sexual means have not been provided to them because of the medical problems that they would be facing by themselves. So now they have to go for IVF. If the assisted reproductive technologies, the IVF and all the other procedures, that is allowed to them. But even if that is not meant properly, even if that is not allowed, that is not achieved by them because of the medical history that the intending couple holds, only then in that case they can perform surrogacy. Your Lordship, they have to go to two particular grounds first of all, that is the natural means and then to IVF means, and even if they don't pass on both of them, then only they can achieve surrogacy. When we talk about the individuals from trans women and a union, they themselves cannot have the first particular, that is through natural means. They cannot have a child through natural means, so they cannot have a child through surrogacy of their own. That was a clear reasoning that was provided by the state. Your Lordship, that was a contention of the learned with that we have not provided the certain classifications. We have not provided the reasoning behind the certain classifications. All the reasonings have been provided under the Lok Sabha debate committee reports, the Rajya Sabha debate committee reports, and the select committee report. Your Lordship, moving forward with regards to that, one of the reasons that there is a principle of parents between, which allows the state to prioritize welfare of the child over the desire of the intending parents, which means that for us being a state, the first priority is the child, though he is not presently alive, but he will be born later on, she will be born later on. His or her rights are to be taken into consideration and have to be prioritized, because that is a particular child which doesn't have an identity for now. Either the state has to give an identity to that particular child, or either the intending parents. And to take a note of that particular thing, the state brought a particular act wherein restrictions were made, and restrictions were made with a good...
Can you please quote the relevant provision in the act?
In your Lordships?
Can you please quote the relevant provision in the act?
In your Lordships, may I access the act? Much obliged, Your Lordships.
So the arguments must be based on law.
In your Lordships. Your Lordships, when it comes to the Surrogacy Regulation Act 2021, the immediate first para has been given as a statement of objects and reason, wherein the state have defined on what grounds they have made this particular act and what is the reasoning behind making this particular act. And moving forward, the particular sections of the act wherein rights of the child and has been provided in section 8 of the particular act, and the definitions have been provided under section...
That is not matching your argument, sir.
Your Lordships, may pardon? May the Lordship pardon?
Provisions you are quoting, no, they are not matching with your argument.
Your Lordship, it does match with the argument, because the purpose of the act that has been defined by us is for the problems that women will be suffering, the problems that child will be suffering. The principle of parents petui has been taken into consideration because of the problems that child will be facing. And that is the reason the principle of petui has been taken into consideration, and statement of the objects and the reason also matches the arguments of the learned council. Your Lordship, probably if the council have satisfied the honorable bench, may the council move on, or any other questions is to be noted by the council. Much obliged, Your Lordships. Much obliged. Your Lordship, there was also one consideration of the learned petitioners, that how can sex be a reason through which a classification was made. Your Lordship, in the case of Yusuf Abdul Aziz versus the state of Bombay and Hussain Boy Lalji, sex was considered as a permissible classification. The same has been mentioned on page number 99 to 104 of the compendium of the respondent, wherein it was stated by the court, for the convenience of the bench, I shall exact mention the statement that was quoted by the bench of that particular case, was that Article 14 is general and must be read with the other provisions which set out the ambit of fundamental rights. Sex is a sound classification, although there cannot be a discrimination in general. On that ground, the Constitution itself provides for special provisions in the case of women and children. The purpose of the act is to protect the women and children. Even the particular case talks about that protection can be, a classification can be drawn for the purpose of protecting the women and children. And that the same thing has been done by the state. So this was a reasonable classification on why a gender bias point of view has been taken by the state while making the particular act. And lastly, Your Lordship, when we take into consideration certain rights of individuals, when we talk about intending couples, the living relationship couples, we duly recognize they have been, the living relationship couple, they have been recognized under the DV Act. But they have not been recognized as on a petition where a living couple is recognized. A living couple has to register their marriage. The living couple has to marry properly. The registration of living relationship is not a law. Since there's no registration of that living relationship, also there are certain prices that a marriage receives, that prices cannot be given to the living relationship as well, and that prices also include the right to surrogacy. Your Lordship, lastly, with regards to the case of Supriyo versus Union of India, Your Lordship, that particular case itself in 2023 with the facts of 2017, it has been clearly seen through the 6 years of continuous arguments before the Supreme Court that right to child, right to marriage, this two particular rights have not been provided to the whole LGBTQ community except the transgenders. Your Lordship, we are not quoting, we have not dealt upon this particular matter on the grounds that we are not looking upon the morality of the particular case. We are looking upon the morality. The state has taken into consideration the morality and the morality of the present time. The modern morality has been taken into consideration because, referring to the same, the learned petition quoted that we have not taken the morality of the present time and we are living in the past. We are not. Even if the legislature is living in the past, the judiciary in 2023 was living in the past. No, Your Lordship, they have taken into consideration all the facts, the present morality of the present country of Vardhan, and then only made this particular act. Your Lordship, this was with regards to the particular issue. With the permission of the bench, may the council move to the further issue number 4.
Yes.
Much obliged, Your Lordships. May the council bring some water?
Yes.
Yes.
Much obliged. Sorry for the inconvenience caused. Your Lordship, the issue number 4 is with regards to whether the exclusion of foreign nationals from accessing surrogacy and ART services under the Surrogacy Regulation Act 2021 and the Assisted Reproduction Technology Act 2021 violate the fundamental rights guaranteed under the Constitution of India. Your Lordship, there are 8 reasons on the basis of which this exclusion has been made. Moving to each of the reasonings one by one, firstly is the preservation of commercial surrogacy and womb tourism. First of all, we duly agree to the point that even altruistic surrogacy has not been provided to the foreign individuals. I will come to that point later on. Moving forward, firstly talking about the commercial surrogacy point of view is because the learned may talked about a very specific term, a very diplomatic term, that is gestational service. Gestational service is also provided through altruistic means, also through commercial means. Your Lordship, but the problem over here, which has been quoted by numerous individuals, is the womb tourism. This was a term given to commercial surrogacy in India, because in Vardhan, which is a paramateria state of India as well, in that particular country, it was considered a national capital of surrogacy. And with this tag, it also received the tag of womb tourism country, wherein the individuals come from different countries and have surrogacy practices in this particular country, and it was exploiting the women of the particular country as surrogates. Your Lordship, I'll quote the case of Baby Manji Yamada versus Union of India. Your Lordship, in that particular case, the rights of the child was born through surrogacy. The father declined to have that particular child, and later on, when the child was about to go to that particular country from where the intending couples came from, that is Japan, Japan didn't allow that particular child to have the citizenship of that particular country, and because of which the child suffered a lot. Not just this case, even the same case happened in Gujarat High Court, wherein similar facts were taken into consideration and the child suffered a lot because of that. Taking all that into consideration, we brought this act into consideration. Also, there was a concern that we didn't bring regulations. For the notice of this honorable bench, I'll request this honorable bench to take this into consideration. I'll annex this to the honorable bench.
Only one question.
Indeed, Your
If a
Lordships.
foreigner is legitimately staying in our country for a long period of time,
Indeed.
would he be deprived of any of the right which is available to the citizen of this country?
Indeed, Your Lordships.
And
Your
therefore, then, in
Indeed, Your
that case,
Lordships.
then there is a clear prima facie discrimination on the face of record in this act for that particular foreigner.
Your Lordship, when it comes to the case of foreign individuals coming to India and performing surrogacy, they are not coming to reside in this particular country. They are
I'm
just
talking about the foreigner who is legitimately staying in this country, working in this country. For him, what would
for
be-
them, Your
somebody
Lordship,
who is settled in this country legitimately.
who have settled in this country legitimately.
Suppose
Indeed, Your
somebody who
Lordships.
works for the embassy, for that matter.
Indeed, Your Lordships.
Where
With that,
do you go?
indeed, the overseas citizen of this particular country. Your Lordship, when it comes to the case of overseas citizen of this particular country, it is to be noted that they are not they have not granted the absolute citizenship. They have just the rights to stay in this particular country, and they can, whenever they can go back to their own country.
What about a foreigner who works over here in this country for years together? Will he be deprived of this right?
Indeed, Your Lordship, they will be deprived of this particular
Why?
country because they don't hold the citizenship of the India. Only citizens of this particular country has the right to.
Will it not deprive them of their Article 21 right to life then in that case?
Your Lordship, right to life is awarded to the foreigners, but it's not absolute, Your Lordships. We have to take our citizens' rights first, and then only we can provide the rights to the.
See, I do a lot of NDPS matters day in, day out,
Indeed, Your
and
Lordships.
I deal with a lot of foreigners cases. They have to be treated just like our country citizens.
Indeed, Your Lordship,
No different.
Indeed, Your Lordships, they have to be taken into
Do you
consideration.
think there is a discrimination as argued by them?
Your Lordship, there is a discrimination, but a reasonable one, Your Lordships. I shall bring into attention of this honorable court how. Your Lordships, when it comes to the case of many other cases wherein right to life has been provided, Your Lordship, right to life of that particular person is provided. For example, if a person is a foreign individual, if come to India and have the right to life, they duly have the right to life. But that right to life cannot affect the right to life of the other person. When a foreigner comes, foreigner is living in this particular country, when a foreigner is living in this particular country from a very long period of time, then also there is a case wherein all the rights should not be provided is because that particular person will be exploiting the rights of the other person, which will be a surrogate for that particular intending couple. So rights of that particular foreigner is there, but that cannot affect the right of the citizen of this country, who will become a surrogate for that particular person. This was
You can move to the other.
much obliged, Your Lordships. Your Lordship, the first reason was with regards to commercial surrogacy, that is the womb tourism. Moving forward, protecting the surrogate mothers from exploitation and ensuring legal recourse. Your Lordship, there's a case of Jan Balas versus Anand Municipality and others, wherein the Gujarat High Court highlighted legal complexities of granting nationality to the child born via surrogacy to foreign nationals. Your Lordship, Indian surrogate mothers, I have annexed to the Honorable Bench the particular case wherein it was been noted by the Indian medical visa regulations that only and only those countries who will be coming to this, the intending couples coming from international countries, who will be coming to this particular country to have surrogacy practices, have to give compulsorily a affidavit from that particular country's external affairs minister or either the embassy of that particular country, and only then they can have surrogacy in this particular country. This was passed by the Indian medical visa regulations in 2013, but still the problems that the exploitation of child, the exploitation of women continued after that, and that was the reason in 2015 the state took into consideration and banned the whole commercial surrogacy.
Why was it banned? Because there is some reason given in your Moot proposition. Why is it banned?
Your Lordship, I'll bring to the moot.
In its entirety.
With the permission of the bench, may the council continue with the arguments.
The answer is very much there.
Indeed, Your Lordship, I'll quote that. My time is up. May the council take some more time. Much obliged, Your Lordship. Much obliged. Your Lordship, commercial surrogacy was banned for the foreigners in 2015. The reason for that is provided in paragraph number 8 of the Moot proposition, wherein it was seen that the first reason was lack of agency and inadequate compensation for surrogate mothers, along with legal disputes over surrogacy contracts. Thirdly, the custody of newborns. All the things highlighted upon this particular fact that now the commercial surrogacy has to be banned for the foreign nationals.
The reason is because more than 50% of the surrogacies were of foreigners.
Indeed, Your Lordship.
And that was the commercial aspect behind it.
Indeed, Your Lordship.
Why? And there was no regulation. And it led to a lot of exploitation.
Your Lordship.
That is why it was banned.
Indeed, Your Lordship. That was one of the reasons, well quoted by the Honorable Bench, that was one of the reasons, but also, even when the state tried to bring regulations to the Indian medical visa regulations, that we will restrict only those states whose embassy allows that particular child to have that
But on the
citizenship.
flip side, just see a situation. It's a $400 million industry
Indeed,
per
Your
year. Will it not affect your country's revenue or finances?
Your Lordships,
have this kind of a ban.
Indeed, Your Lordships.
Okay.
Thank you.
Thank you very much.
Lordship, may the council lastly quote the answer of the Honorable
Yes,
Bench?
yes.
Only the answer of the Honorable. Your Lordship, for answering the Honorable Bench, I'll answer it with the case of SXZ and XY versus the statelessness of the child. It was a case of NRI. The case has been provided on page number . Page number 223 of the compendium. I shall refer the compendium as well.
What does it say?
Your Worship, that was a case of England and Wales, wherein the intending couple came to India to perform surrogacy. Your Lordship, in that particular case, it was seen that when the couple came to India and performed surrogacy, when they went back, the England and Wales didn't allow that particular child to come in the grant citizenship, even after the Indian medical visa regulations, which intended certain bringing upon certain regulations to commercial surrogacy. Even after that particular regulations brought by the state, the country of England and Wales didn't allow that particular child to have the citizenship of that particular country, and that was the reason we had to ban the same for the Indian couples.
Thank you.
Much obliged for the honorable bench to listen to the arguments. If the lordships may allow, may the council move to the prayers.
Right.
Much obliged, your lordships. Therefore, in the lights of the facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed that this honorable court may be pleased to adjudge and declare that the petition filed by the learned petitioners is to be dismissed, to uphold the constitutional validity of the Surrogacy Regulation Act 2021 and its rules under the Section 4.2b and 4.2c, to declare that the Surrogacy Regulation Act 2021 does not discriminate along the citizens of the country and the classification drawn is in lines with the objective of the particular act, to declare that the upper age limit set by the legislation is brought to balance the right of the child and that the parents and thus within the constitutional ambit, to declare that the exclusion of foreigners under the class of the Surrogacy Regulation Act 2021 therein are justified being based on reasonable classification, and that the act does not breach Vardhan's international obligations and the anti-discrimination principles under the Constitution of Vardhan and international law, and lastly pass any other direction that is honorable court may deem fit.
Thank you.
Much obliged for the honorable bench to listen to the arguments.
The result we just keep it here.
Sorry? Sorry?
They want to give rejoinder and so result.
Oh, all right. Go ahead.
So
Am
what
I-
is the time limit for this? Please adhere to the time limit.
Yes, Your Honor. May I proceed with the rebuttals? Your Honor, the defendant in their memos have cited that commercial surrogacy is a contractual, emphasis on contractual, profit-driven arrangement where a woman's womb is effectively, again, emphasis, rented for a fee. The council, as argued before, only suggested a merely regulated commercial surrogacy. As submitted, Form 2 talks about the contract that is formed in altruistic surrogacy. Why not add a clause? Why is there a distinction between commercial surrogacy and altruism made only on the basis where a surrogate mother is merely asking for the reproductive services that she is providing? Also, the defendants have mentioned that they're effectively renting their womb. Thus, it cannot be equated with organ donation, whereas in organ donation, it is effectively an irreversible gift. Whereas renting of a womb is clearly reversible when surrogacy practices can take place more than once. Also, the ban has taken into consideration the exploitation and the commercialization practices, which was the reason for such a ban. But as mentioned in altruistic surrogacy practices and the legislature, the surrogacy procedure is only allowed once for the surrogate mother. Why not allow the same for commercial surrogacy as well? Why has it been banned only on the basis where the surrogate mother is merely asking fair remuneration for the service that she provides? Also, in altruistic surrogacy, the payment is limited to medical insurance and the pregnancy-related expenses only. What measures has the defendant taken to ensure that in the name of such medical-related expenses and pregnancy insurance, that the surrogate mother is paid nothing? It has been very vaguely defined in the legislature itself. The defendant had also mentioned how marriage is a form of legal stability, and as the honorable bench had contended him with the question that it was as a basis for legal accountability. Then why is it that a widowed woman is allowed? That completely fails marriage as the basis for legal accountability. If effectively a widowed or a divorced woman is a single woman. So if a single woman is allowed, then why is not only single woman or a single male or LGBTQ community members not being allowed? Also, they had mentioned that The reason for not allowing
No,
LGBT...
you have started asking questions to us. In the rebuttal, you must give us this, you must
Yes, Your
say
Honor.
that how their argument is not
I've
correct.
addressed that as well, further on.
Only a foundation.
Sorry, Your Honor.
Yes.
Also, considering the exclusion of foreign nationals, we have suggested a clause where they added regulating the foreign nationals that were coming in, put a block on the money, the medical insurance, all the pregnancy-related expenses, rather than completely excluding them on the basis of their nationality. If the basis of exploitation is taken as the form of excluding them, then we have suggested measures to solve that. If the necessity criteria of the proportionality test fails, the entire provision should fail as well, when less restrictive measures clearly exist, as suggested. Also, the defendant had mentioned that a part of a human body is sold. Here, there is a clear genetic tie between the surrogate child as well as the intending parents. So, regardless of the money, they are not buying or selling their own child. And genetic ability concerning genetic ability, where an age restriction criteria has been put, how is it that the defendant differentiate between someone who has merely passed the age criteria by a year or two and those that are under the age criteria? How is someone that is the age of 51 or 52 different from that of the age of 50? How is that the physical or the mental capability differing that much from that of someone that fulfills the criteria? Also, there has been put an restriction on the age limit that a widow or a divorcee can use the process of surrogacy, which is 35 to 45. This would form an indirect discrimination in the way that you have to marry to avail this service, and if you choose not to marry, you cannot have a child through the process of surrogacy. So that directly affects the right to choice to marriage that was as presented by my co-counsel in the Shafeen Jahan case. That is all, Your
Thank
Honor.
you. The rejoinder is done? All right.
Obliged for the honorable bench to give opportunity with regards to Sir rebuttal. Your Lordship, there were few concerns of the learned petitioners. Again, they come with a few questions. Answering that questions, first of all, with regards to regulation of commercial surrogacy, as I annexed the document, it was a RTI that was questioned to the Government of India. In that particular reply itself, we have quoted that we tried to regulate the particular commercial surrogacy for the foreigners in this particular country. But that didn't work out, because even after that, the particular state of UK didn't allow the child to have that particular rights. With regards to the second question that was portrayed by the learned petitioner was regards to reversible gift. That when an organ is been given, it's an irreversible gift. Okay, Your Lordship, we take that into consideration, but for the particular argument, I shall bring to the notice of this honorable bench the National Blood Policy Guidelines that was provided by the state. Your Lordship, we all are well versed with the fact that blood is reversible. Blood comes back after it's given as a donation.
Right.
Even if blood is given as a blood cannot be bought or cannot be sold. Blood is reversible, but still it cannot be sold. The purpose is for the medical ethics. It is for the purpose of morality. Now, in here comes the purpose of morality. Organ transplantation is irreversible, Your Lordship. Liver transplantations, when it comes to picture, liver is reversible. Even livers are not allowed to buy and sell. If I take someone's liver, I don't have to take the whole liver of that particular person. A part of that liver is taken into consideration. Liver is such an organ which scientifically develops itself and becomes the whole organ. So that is the reason, though being a reversible, it cannot be bought or sold. That was with regards to the reversible gift. Your Lordship, moving forward with regards to why we have allowed only one-time surrogacy. Your Lordship, surrogacy is not just surrogacy, but having pregnancy is such a hideous task for a woman that it affects the body of the whole woman. There were many surveys done by many individuals as well. One of them was Viral Dave ma'am, wherein it was been stated by that particular person in that survey that many individuals, when they were surrogates, because of the commercial surrogacy, went through surrogacy numerous times, many times, 11 times, and because of which they are suffering many medical issues with regards to that. And that was the reason only one time surrogacy was allowed. Moving forward with regards to why we have blocked OCIs, I shall annex to the honorable bench the Government of India, the Ministry of Home Affairs reasonings with regards to the circular number 462, which was most immediate circular, that the OCI has been disallowed. But when we refer to the page number 22 of the respondents' memorial, they themselves have quoted, OCIs are allowed to have surrogacy in this particular country. We have not recognized OCI to have surrogacy in this particular country. Moving forward, the reasoning that was provided by the learned petitioners with regards to the DNA possibilities, that we are not, the particular intending couples is not using the body of the surrogate mother. It does. Embryo is to be taken into consideration. Your lordships, they have mentioned in their arguments a sperm and the egg is fertilized and then it has been put in the embryo. Your lordship, when it comes to prostitution, it is very well stated only the outer body has been used, and that to a particular point of time, and that is with the consent of that particular person. Over here, consent is there, but a 9-month prolonged time is to be provided by the particular surrogate.
All right.
Your lordship, lastly, this was with regards to the rebuttals of the respondents.
Thank you.
Much obliged, your lordship.
Thank you.
Whom do we give the result to?
Results are they are kept in this.
Thank you, participants, for your efforts. Thank you, judges, for this spectacular round. We shall now take a short break. Students are requested to remain seated. Students are requested to remain seated. I repeat, students are requested to remain seated in their places. Please don't get up. Students, I request you all to remain calm and stay seated.
Hello, hello, hello. Everybody, आ रही है आवाज़? Hello,
Hello, hello.
hello. Everybody is please requested to please be seated. Everybody please be seated in their places and please maintain silence. Please maintain silence and please be seated.
We will be serving some snacks for all of you here. I request all of you to not litter the auditorium and pass the boxes to us, okay?
बसून घ्या. अरे बसून घ्या.
Check, hey, hey, check, hello, hello, check. Hello, check, check, hello, hello, check. Hey, test, hello.
Dignitaries. Good evening, everyone. It is my privilege to welcome you all to the valedictory ceremony of Sparkle 6.0, the 6th Law Festival of KLE College of Law, Navi Mumbai. Over the past few days, we have witnessed outstanding legal prowess, compelling advocacy, and intense intellectual discussions. The dedication and enthusiasm of our participants have truly made this event remarkable. We have the privilege of having with us the chief guest of this valedictory ceremony, Honorable Mr. Justice Arvind Kumar, Judge, Supreme Court of India. We also have with us guests of honor, Honorable Mr. Justice P.S. Dinesh Kumar, Presiding Officer, Security Appellates Tribunal, and former Chief Justice of High Court of Karnataka. We also have with us Honorable Mr. Justice Milan Jadhav, Judge, High Court of Bombay. We also have with us Professor Dr. Somu C.S., Professor of School of Law, Christ University, Lavasa. And we are very happy to have with us the President of this event, Honorable Dr. Prabhakar Kore, Chairman, KLE Society, Belagavi, along with all the members of Board of Management, KLE Society, Belagavi. As we begin this momentous occasion, let us take a moment to seek the blessings of the Almighty for the success of this event. I invite everyone to join us in invoking the divine presence and positivity through the invocation song. I request Anupama Nair to sing the song.
Vakratunda Mahakaya Suryakoti Samaprabha Nirvignam Kurme Deva Sarvakareshu Sarvada.
Thank you, Anupama. May I now invite Dr. Amrita Singh, Associate Professor and Academic Coordinator, to deliver the welcome address and warmly welcome the gathering.
Thank you so much, ma'am. Honorable Mr. Justice Arvind Kumar, Judge, Supreme Court of India. Honorable Mr. Justice Milind Jadhav, Judge, High Court of Bombay. Honorable Mr. Justice P.S. Dinesh Kumar, Presiding Officer, Securities Appellate Tribunal and former Chief Justice, High Court of Karnataka. Professor Dr. Somu C.S., School of Law, Christ University, Lavasa. Honorable Dr. Prabhakar Kore, Sir, Chairman, Keli Society, Belgavi. Respected members from the Board of Management and life members of Keli Society, esteemed faculty members, dear students and participants. A very warm and heartfelt welcome to all on this prestigious occasion, the valedictory ceremony of Sparkle 6.0 Law Festival at Keli College of Law, Navi Mumbai. Today, we gather to celebrate the culmination of an event that has been a confluence of intellect, advocacy, and the spirit of legal excellence. On behalf of Keli College of Law, Navi Mumbai, I extend my sincere gratitude to our esteemed dignitaries for taking the time to be part of this special occasion. Your presence here today is a source of great encouragement for our students, and we look forward to hearing your invaluable insights and words of wisdom. Before we proceed further, it is our privilege to felicitate our distinguished guests as a token of our deep appreciation and respect for their contributions to the legal fraternity. Firstly, I would request our respected Chairman, Sir, Dr. Prabhakar Kore, Sir, to felicitate our chief guest for today, Honorable Mr. Justice Arvind Kumar, Sir, Judge, Supreme Court of India. Thank you, sir. I now request Shri Mahantesh Kavadgimat, sir, Member, Board of Management, Keli Society, to felicitate our guest of honor, Honorable Mr. Justice P.S. Dinesh Kumar, sir, former Chief Justice, High Court of Karnataka. I now request Shri Shankarana Munavalli, sir, Member, Board of Management, Keli Society, to felicitate our guest of honor, Honorable Mr. Justice Milind Jadhav, sir, Judge, High Court of Bombay. Thank you, sir. I now call upon Shri Jayanand Munavalli, sir, Member, Board of Management, Keli Society, to felicitate our guest of honor, Professor Dr. Somu C.S., sir, School of Law, Christ University, Lavasa. Thank you, sir. I now call upon Professor Dr. J. M. Mallikarjunaiah, sir, Member Secretary, Director, Keli Law Academy, Dean, School of Law, Keli Technological University, to felicitate our Honorable President of the session, Shri Dr. Prabhakar Kore, sir, Chairman, Keli Society, Belgavi. Thank you, sir. I now request Professor Harsh Singh, sir, Assistant Professor, Keli Law College, Bangalore, to felicitate Professor Dr. Dinkar Gitte, Principal, Keli College of Law, Navi Mumbai. I further request Dr. Lalita Bhosle to felicitate Shri Mahantesh Kavadgimat Sir, Member, Board of Management, KLE Society, Belagavi. I now call upon Assistant Professor Pooja Bijargi to felicitate Shri Shankaranna Munavalli Sir, Member, Board of Management, KLE Society, Belagavi. I now call upon Assistant Professor Bipasha Bandyopadhyay to felicitate our Member Secretary, Professor Dr. J.M. Mallikarjuneya, Director, KLE Law Academy, Dean, School of Law, KLE Technological University. With that, I once again extend a warm welcome to all our distinguished guests, faculty members, students and participants. May this event mark the beginning of new aspirations, greater achievements and continued excellence in the field of law. Thank you very much.
Thank you, ma'am. I now invite Assistant Professor Mr. Akash Mishra to read the event report of Sparkle 6.0.
Thank you, ma'am. Very good evening to everyone. Good evening to the dignitaries. So Sparkle 6.0, the 6th Law Festival organized by KLE College of Law, Navi Mumbai, showcased the intellectual rigor and advocacy skills of participants in two flagship competitions, the National Moot Court Competition and the National Client Counseling Competition. The event brought together almost 50 teams from all over the schools of this country, including IILM University, Gurugram, Alliance University, Bangalore, KES College of Law, Kandivali, DSNLU, Visakhapatnam, National University of Advanced Legal Studies, Kochi, MNLU, Nagpur, MNLU, Aurangabad, Symbiosis Law School, Pune, Christ University, Lavasa, amongst many others. The event took place in a hybrid format, wherein preliminary rounds took place online on 8th and 9th of March, followed by the semi-finals and finals on 21st and 22nd. Sparkle 6.0 saw students engage in intense legal arguments and dynamic client interactions. It not only provided participants legal acumen, but also with the real-world simulation of such scenarios. The event was adjudicated by an esteemed panel comprising practicing lawyers, district court judges, and academicians, whose expert insights elevated the competitive experience for the participants. Having witnessed research arguments, persuasive advocacy, and commendable articulation, we gather here at this hour for the valedictory ceremony to honor our winners. Thank you.
Thank you, sir. I now request Assistant Professor Ms. Ashna Bansal to introduce the President of the valedictory session, our dear Chairman, Shri Prabhakar Korye, sir.
Good evening, everybody, and good evening, respected dignitaries. It is an honor and my privilege to introduce our Honorable Chairman of the KLE Society, Dr. Prabhakar Korye, sir. Sir has been 3-time Member of Parliament, Rajya Sabha. As an educationist, Sir is the Chairman of KLE Society, Belagavi since 1984. Under his leadership, KLE has grown from 38 institutions into an organization of global repute with 310 institutions with 1,45,000 students and 18,000 staff. Sir is the Chancellor of KLE Academy of Higher Education and Research, Belagavi. Sir is also the Chancellor of the KLE Technological University, Hubali. Sir has placed KLE on the global map through various research and community healthcare activities. Sir has received several accolades, including honorary doctorates and other felicitations for contributions to education, healthcare, research, and social welfare. As a multifaceted personality, Sir continues to contribute significantly in the fields of education, agriculture, research, science, healthcare, politics, and community welfare at both domestic and international front. I now request Dr. Shri Prabhakar Kore sir to kindly address the gathering. Please, sir.
Good evening to everybody. Honorable Justice Arvind Kumar, Judge of Supreme Court of India. Honorable Justice Milind Jadhav, Judge High Court, Bombay. Honorable Justice P.S. Dinesh Kumar, former Chief Justice, High Court, Karnataka. Professor Dr. Somu, School of Law, Crest University, Lawas. Principal KLE Society, Professor Dinkar Getty, Honorable Director KLE Society, dear students and faculty, I am very happy to be here because, sir, this is a 10 years old baby, Law College, this Bombay. So presently we are running our 6th law college. KL is running 6th law college in various, including rural law college in Chikodi. So you being a son of Karnataka, I think you know much how KL has grown and what is the KL's performance and this. So about 109 years back, the 7 graduates from Dharwad, Belgaum, Bijapur, they are all studying in Pune, Ferguson College. They become my friends. After their graduation, post-graduation, they didn't go to job. Otherwise, they would have given those days collector job in British time. They know the hardship of getting their education in reaching Ferguson College. So all after graduation, they decided to start a education institution in Belgaum, because Belgaum have only 2 schools, sir. One is St. Paul High School is meant for only British. Belgaum was a headquarter for army headquarter for British people. Their children only they get the admission. Second school was Sardar High School, sir. The Sardar High School is always, Sardar, Jamindar, only meant for them. These 7 teachers, they were very hardship to study. They didn't get even one of this person, he comes from Gokak Taluka, sir. Those days, he stood first to the Belgaum district in Mulki Pariksha, that is 7th. It was Mulki Pariksha is like a today's graduation. But he didn't get the admission in Belgaum because he didn't have a background of education. Mother was only mother, they don't have father. And mother was doing very small, putting a color on clothes. So because of that profession, they didn't allow, sir. So these 7 people, various 7 people, they have some more problems. So after graduation from Ferguson College, they decided not to go job. If a community or until we educate them, it's not possible. All 7 people came to Belgaum. They have rented one small bungalow in port in Belgaum. And they themselves become a teacher. Because to pay the teacher's salary is very difficult those days. And they started one school in 1915. And there are 3 philosophers, sir. They help the further. So with these, we call them Saptarushis, 7 people, the teachers. And presently, even whatever teacher they are working in my society, they are highly respected in my institution, sir. That is and there are, this society is established by these 7 teachers on democracy setups. We have almost 8,000 members. Every 5 years we have election. Our election is like a assembly MLA election, sir. But luckily, last 20 years there is no election. So there are 12 members from this general body, they elected from members. And there are 3 teacher community, they are in board, sir. There are totally 15 people on board. And there is a parallel board also there, sir. We call them life members. They are all teachers. So they guide for us academically, and they look after the academic. And most of them are board members, they have industrialists, they are business people. So we are working as a part-time, as a social work in this. And presently I am happy to inform you that when we started one small school, we are running now 310 colleges school in Karnataka, Maharashtra and Delhi, sir. In up to 95, there is no medical facility in that part of country, sir. Looking after this, we started a hospital, small hospital, about 300 bed, to just create the health care to poor people. After that, we decided to go for a big hospital. First, in 1996, we built the 1,000-bed hospital in Belgaum, inaugurated by then Prime Minister Narsimha Rao ji. And today, there even 1,000 is not enough now. So in one campus, I have 2,400 bed. Out of 2,400, 1,200 totally charitable. We are not any charges, just to give the best of the best facility, food 2 times, lunch, dinner, breakfast and evening snacks. And basic operations will be totally free. The delivery poor people totally free. And under 1,200, we have called super specialty, where such a small place in Belgaum. Presently, we have heart transplant facilities. We almost done about 8 heart transplant, liver transplant, kidney transplant, lung transplant, so everything, sir. So presently, our total hospitals bed strength is crossed more than 5,000. We have started satellite hospital in Goka, Chikkodi, in North Canara, Ankola. And so totally more than 5,000 bed we are staying. Because this is a commitment of social work of this KLE society. Coming back to Mumbai, sir. Mumbai is the capital of our Indian economy. So our dream to start 2 institutions, one is in Pune, where that all 7 people studied, and their first, they thinking or their knowledge had come to start a school, it was in Pune. So we started 300 bed hospital in Pune, sir. And in Mumbai, with this is just a piece of land is allotted by the authority, and we build this, and next to this there is a separate building for law college, sir. Maybe next time when your visit will be, there is a separate law college, you will find this. That is the... So now, sir, one of the oldest engineering college in Hubli is started in 1946, and that under the Bombay University, sir. And we have very strong alumni, like Infosys lady Sudha Murthy is our ex-student, and one Mr. Sahasrabuddhe, he was a IICT commission chairman, and there are many. So you know that we have produced almost starting from Ballister Nath Pai, Socialist Party. He was our student. He was a member of Parliament. Then Mr. Shankaranandji, who was a law minister, then health minister, again is our student. We are given 2 students who are the chief minister of Karnataka. One is Mr. Bommai sir, and another is Mr. Jagdish Shettar. And in Central, Anant Kumar was our student, sir. President Prahlad Joshi is our student. So we are not only politically, we have many people have become a scientist and even great doctors also, because our medical college, third oldest private medical college in the country, sir. So even in Bombay, you will find many doctors, they are my students, and they are practicing very well in Bombay Hospital and bigger hospital. So with this, I know that you know much about this society, because he comes from, he is a son of Karnataka, so I don't want to take, but just to give to Honorable Jadhav. So this is a really, I'm very happy to, you all people are here. I'm proud that lastly your presence makes students very, very this thing. And they are really, still has to grow this institution. I think next 5 years you'll find the change and everything. Thank you very much. All the best.
Thank you, Chairman Sir, for illustrating the glorious history of KLE Society. We are very proud to be a part of it. I now request Ms. Ranjana S., Assistant Professor, to introduce Honorable Mr. Justice Milind Jadhav, Judge, High Court of Bombay, and to invite Lordship to address the gathering.
Thank you, ma'am. A very warm welcome to all those present here. It is indeed my privilege to introduce His Lordship, Justice Milind Narendra Jadhav, to this august gathering. Justice Jadhav embarked on his educational journey at St. Teresa High School, Charni Road, Mumbai, and later graduated with a degree in life science and biochemistry from St. Xavier's College, Mumbai in 1990. His academic interests expand further when he pursued an advanced diploma in computer software, systems analysis and applications from Apple Industries Limited in 1991, followed by a postgraduate diploma in personal management and industrial relations from the Rajendra Prasad Institute of Communication and Management, Mumbai. Justice Jadhav's passion for law led him to complete his LLB from Government Law College, Mumbai in 1995 to 1996 and his LLM from Mumbai University in 1997 to 1998, where he earned prestigious recognitions including the Firdaus H.J. Talarian Khan Memorial Gold Medal for the highest marks in constitutional and administrative law. Beginning his career as a senior clerk in Western Railway, Justice Jadhav later transitioned to the legal field in 1997. He undertook his internship under the guidance of Mr. P.Y. Kulkarni and was enrolled as an advocate in 1998. He honed his legal expertise by joining the chambers of Senior Advocate Mr. Atul Motilal Setalwad and worked with Senior Advocate Mr. Chandrasekhar Manohar Kode, practicing primarily in constitutional law, land acquisition and commercial laws. His legal acumen also extended to teaching as he served as a part-time lecturer in land laws, environmental laws and civil procedure code at Siddharth Law College in Mumbai from 1998 to 2000. Justice Jadhav's significant contributions as a standing counsel for the custodian in the Special Court for Trial of Offences relating to transactions in securities 1992 further exemplified his expertise in complex legal matters. On 23rd August 2019, Justice Jadhav was elevated as an additional judge of Bombay High Court and was conferred a permanent judgeship on 1st June 2021. His exemplary legal career, combined with his deep understanding of constitutional and commercial law, continues to inspire and shape the legal landscape of Maharashtra. I now invite Lordship to address the gathering.
Thank you, dear Speaker. Respected Shri Arvind Kumar Ji, Judge Supreme Court of India, respected Shri Dinesh Kumar Ji, former Chief Justice of the Karnataka High Court, respected Dr. Somu, Dr. Kore, and the principal of this college on the dais, the faculty members of this august institution, a lot of students whom I see in the audience. Wish you all a very warm good evening. Thank you for having me here, because had I not been here today, I would not have known what this institution is. So, thank you, Dr. Gore. Because until I landed over here, I thought KLE, the K in KLE stands for Kalamboli. Believe me, I must confess, I didn't really read, and when Dr. Kore told me the background which he narrated to you in his speech, I was flabbergasted, I was overwhelmed by looking at the diaspora of work that this institution has done for the betterment of the masses, the polity, and the phenomenal rise that this institution has had. I congratulate this institution for this. Thank you, KLE, for making a difference to the life of the society at large. I see a lot of students in the crowd, and they all appear to be law students. Probably most of them at the threshold of their lives, to enter the legal profession, unlike our times when law was considered to be a default profession. So I'll try and keep my speech as brief as possible. What I always tell students is, this is a noble profession. The nobility is not dead. There may be a little bit of commercialization which has crept into this profession, but then I always attribute it to the development that is happening. The nobility of this profession is par excellence. It is beyond any other profession. Let me tell you that, because I do experience it in my own household, where my wife and my elder daughter are doctors. And when we spar on intellectuality, I always come out as the winner. The reason is, you are touching the life and the cord and the fabric of the society. And therefore, the attributes that are required by a person who embarks upon this journey, like most of you all would be doing in the near future, is what I tell all of you all to remember, the students to remember, are the 3 I's and the 5 P's. So it's very easy to remember. The 3 I's are industry, intellect, and integrity. Industry and intellect can be acquired by each one of you all, even from today or now onwards. Remember that. They say there's no substitute for hard work, and everybody will say you'll have to work very hard in this profession. Intellect is something which you will acquire by applying yourself. But this profession stands out because of the 3rd I, that is integrity. Justice Abbott Perry wrote a beautiful piece on the word honesty in his book called 7 Lamps of Advocacy. And he said, this is the only profession which banks upon the foundation of honesty and nothing else. So remember, students, friends, the 3 I's are so important for you all when you embark upon this journey, that if you embrace them, I can assure you, you will try and break the big block of mediocrity and be a head turner in life. Now you have to just combine these 3 I's with the 5 P's. It's as simple as that, students. The first P which I would like to introduce to you is pride. Therefore, I want to congratulate all of you all. We all need to take a lot of pride that we have chosen this profession. You all have chosen this profession to make a difference. If you take pride, your confidence will also increase. This profession is a persuasive and a tolerant profession. So the next P is patience. You need to have a lot of patience, persuasiveness. You need to wait for reciprocity in this profession. The next P would be perseverance, hard work over a period of time. And when you will embrace these virtues, values, there is bound to be a paradigm shift, which is the 4th P. And these are values which will be governed by what? By the 5th P, which is peer group. From today, your peer group has to be with having friends with common interest, who will probably make you reach your destination and goal as early as possible in whatever achievement you desire to have in the legal profession. So all that I can share with you all is just embrace the 3 I's and the 5 P's, and I'm sure you will be a much better person. That apart, what I would like to tell you all is, please don't ever feel embarrassed to ask for something as a fresher in this profession. Don't have an inhibition or a thinking that if you ask for something and if the answer is no, it's going to be a rejection for you in life. A no means a no, just leave it at that and go to the next person. The reason why I'm telling you is because this is a profession where a lot of good people exist. So therefore, keep on tapping. Don't feel embarrassed. And another quality which all of you will have to embrace at the inception is not to be pretentious, because this is another a profession where you will get caught. Don't ever be pretentious. Be what you are in life. But equip yourself with the 3 I's and the 5 P's. And all this, I just put them into 2 words. The 2 words are backward integration. If you put these qualities and virtues and values, you will be able to achieve your goal as early as possible. I always tell students that when you are studying in college, of course, do enjoy your college activities, but also get introduced to the legal profession by undertaking internships with lawyers at the bar, with judges in the courts, in order to get yourself introduced to this profession. Don't waste your time and see that you get introduced. Go to the bar, make some visits to the bar, join somebody. I am sure you will be a much better off person, because by the time you get your degree, I want each student to ensure that he or she is in a position to make a considered choice. We don't want your gestation to start after you get your degree in your hand. And therefore, this is the best time for you all to set out. But remember one thing, enjoy your college, because the memories that you will have in college will never be there. All that I would like to tell you all is thank you very much for inviting me over here today. I thank this institution, and I wish that the noble work that this institution is doing it spreads to many more places, many more students. Because education is one medium where we all can make a difference, not only to the life of the society at large, but to our nation. Thank you very much, Dr. Kore and his team, the principal who took the trouble to come to my office, my esteemed senior judges who have inspired me. Because I must say one thing before I part. On YouTube, I saw a video of Justice Arvind Kumar ji, and he started off with a Sanskrit shloka. And it was wonderful, I must say, at some lecture which he had given. And he explained the meaning of that in English. I think it must have been 6 months ago or at some place where he had delivered a lecture. So why did I share this with you? See the force that we have, from the teachings of our land. See, we may all have learned English. The Britishers did a good thing by teaching us English. They introduced the English Education Act in 1835, which then went on, which was the precursor to the enactment of the various laws, by Lord Justice Macaulay. But at the end of the day, we have made good progress, good strides. And all this is because all of you all. Wish you all the very best in life. Listen to your parents. See that you fulfill the aspirations, which is the most fundamental thing. Remember, listen to your teachers and take care of your health and your family. Wish you all the very best. Thank you very much.
Thank you, sir, for your enlightening address. I'm sure your words have inspired our students and will encourage them to excel in the profession. Now, I request Assistant Professor Ms. Bipasha Bandyopadhyay to introduce Honorable Mr. Justice P.S. Dinesh Kumar, Presiding Officer, Securities Appellate Tribunal and former Chief Justice, High Court of Karnataka, and invite Lordship to address the gathering.
Good evening to the respected dignitaries on the dais and off the dais, participants of the National Law Fest Sparkle 6.0, faculties and students of KLE College of Law, Navi Mumbai. I, Ms. Bipasha Bandyopadhyay, Assistant Professor at KLE Society's KLE College of Law, Navi Mumbai, take great honor and privilege in introducing our guest of honor, Honorable Mr. Justice P.S. Dinesh Kumar, Presiding Officer, Securities Appellate Tribunal, former Chief Justice, High Court of Karnataka. His Lordship embarked on his legal career in 1990 at the chambers of the Honorable Mr. Justice Shivraj V. Patil, former Judge of the Supreme Court of India. Over the years, His Lordship has held several prestigious positions, serving as Senior Standing Counsel for the Government of India and representing key institutions such as CBI, BSNL, UPSC, UGC, All India Council for Technical Education and National Council for Teacher Education. His Lordship has also served as Standing Counsel for Karnataka Power Transmission Corporation Limited, Kerala State Road Transport Corporation and Bangalore Electricity Supply Company Limited, playing a crucial role in shaping legal policy and governance. In recognition of His Lordship's exceptional contribution to the judiciary, His Lordship was appointed as an additional judge of the Karnataka High Court on 2nd January 2015 and was subsequently made a permanent judge on 30th December 2016. His Lordship's tenure as Chief Justice of the Karnataka High Court further exemplified his judicial wisdom and commitment to upholding the rule of law. Since 29th April 2024, His Lordship has been serving as the presiding officer of the Securities Appellate Tribunal, continuing to shape legal jurisprudence in the field of financial and securities law. On behalf of everyone present, it is my great honor to welcome His Lordship, Honorable Mr. Justice P.S. Dinesh Kumar. We are truly privileged to have your Lordship with us today. Ladies and gentlemen, please join me in extending a warm round of applause for our esteemed guest as he takes the stage to address the gathering.
Very good evening to everybody. Honorable Justice Mr. Arvind Kumar ji, Judge Supreme Court of India. Honorable Justice Milind Jadhav, Judge High Court of Bombay. Shri Prabhakar Kore ji, Dr. Somu, Dr. Dinkar Gite, members of the KLE Society, dear students, ladies and gentlemen. It's indeed a great pleasure to be here this evening. Dr. Kore's esteemed institute has been calling me to their functions at Hubli, at Bengaluru, Hubli, etc. The population there in that area, and particularly in that area and in Karnataka generally, know the Karma Yogi sitting here and the institution and the contribution that they have made in every field, starting from education, healthcare, and upliftment of the poor, etc. I'm so happy and glad to note that they have extended it to Maharashtra, and as an obeisance to the Sapta Rishis whom the Dr. Kore referred to, that they have started their institution in Pune. Coming to today's function, it's so heartening to see so many youngsters who have taken this profession by choice. Justice Yadav mentioned that it used to be by default for some time, for a few years ago, but it's so heartening that now you have all chosen this profession by choice. This school from where both myself and His Lordship Justice Arvind Kumar are the alumnus, National High School and National College. We have in our emblem it is written as the Nahi Jnanena Sadrisham. See, there is no substitute for knowledge. In a more or less a similar synonymous slogan, the Karnataka University also contains a very similar one saying that Arive Guru, which is knowledge is power. Post 1999 December 31, meaning once the new century has begun, 2001, there has been a phenomenal change in the societal norms and the societal status and the societal values. The subject that today's moot court, or which was being argued by the young budding lawyers who are going to become lawyers, one could not have even conceived such an idea maybe about 50 years back. The value system has changed. But having said that, I completely agree with Justice Jadhav saying that with all this is a field that you have, it's noble and you have taken it by choice. you have an onerous responsibility to see that the litigation is not just reduced, litigation is almost wiped out. Generally, I can recall for the last about 50 years when we are in the school, anything would happen, people would go to a lawyer, get a legal notice issued and start litigation. The other man would go to another lawyer, file a written statement, and then, it would start, the litigation would start. One fundamental thing which all of us will have to, and more particularly the young students who are going to become lawyers have to think and keep it in mind that both the plaintiff and the defendant, if not anybody else, will be knowing the truth. Leave about criminal cases, let's not talk about major civil cases. Both of them will be certainly knowing the truth, but nonetheless, the litigation will go on from trial court to the first appellate court and second appellate court, Supreme Court, etc. That means, you see, on one side, ultimately some decision will come, that's a different matter. But on one side, the affidavits or the evidence on record will go on the aspect of truth, and on the other side, it will be otherwise, which both parties know about it. Therefore, why I said this, because now that ethics in your profession and the legal profession is so very important, that it is not only that you will do a great service to yourself, service to your clients, and service to the society. That's where that not having been able to contain this litigation, we have time and again the Parliament has brought in amendments, and the latest being Section 89 to bring in alternative dispute resolution system. We have practiced and grown at the feet of such very elderly and very senior, celebrated, honest lawyers who have had the courage of saying, sorry, you don't have a case, don't file an appeal. I would strongly appeal to you, all youngsters, to please have this motto in your mind, that it's not that you should not have a good living, it is not that you should not have a sparkling career, it is not that you should not have a fantastic profession and as also the practice, but at the same time, at the end of the day, all human beings who have come to this world have as a token of our gratitude, we will have to repay something to the society, and in that, those who are in the legal profession, in my opinion, is that we must ensure to see that as much the efforts that we will be able to put in to see that we try to reduce the litigation in this country. We have had the number of dockets which are exploding by the day, and it was little disturbing sometimes. Of course, compared to 140 crore population, the numbers may be less, but nonetheless, the time taken from the entry-level court to the Supreme Court, the time taken is so much that the litigants end up in frustration. Ladies and gentlemen, I am greatly indebted to Dr. Kore and the KLE Society for calling me here, and I feel at home in Mumbai to be in this institution, and so glad to see so many youngsters. We wish you all the very, very best in your career, and for all that you have done in these days in the Moot Court competition. I'm sure that would take you to heights, and wish you all the very, very best. Thank you for your patience.
Thank you, Lordship, for your valuable insights. Your emphasis on the role of ethics in law will surely inspire our students to uphold justice with honesty. I now request Ms. Pooja Bajargi, Assistant Professor, to introduce our Chief Guest, Honorable Mr. Justice Arvind Kumar, Judge, Supreme Court of India, and invite Lordship to address the eager gathering.
It is my privilege to introduce the chief guest for today's event, Honorable Mr. Justice Arvind Kumar Sir. His Lordship pursued schooling and higher education in Bengaluru. Lordship completed his undergraduate studies at National College and obtained law degree from Bangalore University. Enrolled as an advocate in the year 1987, Lordship initially practiced in trial courts for approximately 3 years before shifting his practice to the High Court in the year 1990. Lordship subsequently established an independent legal practice. In the year 1999, Lordship was appointed as Additional Central Government Standing Counsel at the High Court of Karnataka, and in the year 2002, Lordship was appointed as a member of Regional Direct Taxes Advisory Committee by the Government of India. In the year 2005, Lordship was appointed as the Assistant Solicitor General of India. Lordship also represented in numerous election petitions relating to the Assembly and parliamentary constituencies and served as a standing counsel for the Income Tax Department for about 11 years. His Lordship was standing counsel to several statutory corporations. Additionally, Lordship was associated with various voluntary organizations and served as Special Public Prosecutor for CBI, Central Bureau of Investigation, until the elevation to judiciary. In the year 2009, Lordship was appointed as an additional judge of Karnataka High Court and was made a permanent judge in the year 2012. Lordship later served as Chief Justice of Gujarat High Court from the year 2021 and remained in the office until 2023. Lordship was elevated to Supreme Court of India in the year 2023, where Lordship continues to serve with distinction. As a Supreme Court judge, Honorable Mr. Justice Arvind Kumar Sir continues to contribute significantly to the Indian jurisprudence, shaping important legal precedents and upholding the constitutional values. I would now request our Chief Guest, Honorable Mr. Justice Arvind Kumar Sir, to please address the participants.
A very good evening to dignitaries on the dais, off the dais. My esteemed brother, Justice Milind Jadhav, Judge, High Court of Mumbai. Justice Dinesh Kumar, former Judge and former Chief Justice of Karnataka High Court, now the Presiding Officer of Securities Appellate Tribunal. Dr. Somu from Christ University. Dr. Dinakar Gitte, KLE Law College Principal, and not forgetting the icon of KLE, Dr. Prabhakar Kore, and his committee of members, his soldiers or commanders of the army who run the institution, who are all present in great numbers. And the most important, you must be thinking yourselves, no, before that, it is Guru Brahma, Guru Vishnu, Guru Devo, Maheshwara, Guru Sakshat Parabrahma, Tasmai Shri Guruve Namah. The teachers, professors, lecturers who are teaching you, whom you have to salute to them every day throughout your life. The learned teachers, the staff, all other persons, learned advocates who have come all the way from Karnataka and also Delhi, and my dear students. Let me put it to you in this way that I will be as brief as possible for two reasons. Number one, before I came to Mumbai, I went to Bangalore yesterday late night. I had to see one of my friend's father who was ailing. So I went to Bangalore. In the afternoon, I flew to Mumbai. Before I flew down, I visited my daughter She said, where you are going, why you are going to Mumbai? I said, I am addressing a student. She said, don't eat their heads. And second reason is I will have to catch a flight back to Delhi tonight itself. So I have to rush back. So in my own interest also, I will be as brief as possible. I will not say that I am rendering a erudite speech like our brother Justice Jadhav and Justice Dinesh have done it. I will just share few thoughts which has just come before me. You have all participated in this great moot court competition and other competitions which have been conducted. Some of you are from national law universities. Some of you are from very esteemed, reputed colleges. Some of you might be from new colleges, the colleges which have just started few years back. And some of the students, majority of the students may be having an apprehension in the mind that will I be able to compete with the students who have come from great colleges, big colleges. You will have that infra dig. Never ever be under that impression. Consider yourself you are the best. Self-esteem is the most important thing for any person. And I will give you the reason also. I did not come to this profession, legal profession, by choice. Let me be candid in my confession. It was my father who persuaded me. I have been repeatedly telling in many forums. I wanted to become a progressive farmer, agriculturist. But my father said, no, you should become a lawyer. Every time when you sit for breakfast, lunch, dinner, he said, you are joining, no? Are you becoming a lawyer, no? So every day we used to fight at the dining table. So, and every day my mother used to be the mediator and console both of us. This happens in everybody's house. So one fine day I was so fed up, he said, I had to take a call. So he said, no, you please give me one good reason why you will not become a lawyer. I said, I am not interested. I am not interested. I had to study throughout my life. I am not interested. Then he took out his diary and he said, look here, 97% of the first parliament, 97% of the members, parliament members were lawyers. I said, I do not want to become a politician. He said, no, I am telling you about political leaders, not politicians. Then he said, 87% of the first legislative assembly of Karnataka, 87% of the MLAs were lawyers. They came from legal profession. I said, so what? Because I used to fight with my father very vociferously. He said, it is the lawyers who can change the course of the country. It is only the lawyers who have the capacity to change the society. The lawyers, he said, they are social doctors. He did not stop at this, and he said, I have one more important reason. He said, I wanted to become a lawyer, but I could not become, so you should become. I said, you should have become, why should you trust on me? I will choose my profession, whatever I want. So then he said, look here, 1944, he was imprisoned. Now imprisoned for not any other reason, he was in freedom movement. He was accused number 2 in All India Bombay, Mysore All India bomb case, and he was convicted for 4 years. So he was inside the jail. I was told, he used to tell me that in the jail, they used to serve the dinner by 7 o'clock and put all the convicts inside the barrack or that cell by 7:30. All of them were young. So 7:30 they are not used to going to bed so early. And in cell it is not air conditioned or anything, it will be with a lot of mosquitoes. So what they used to do, they have to kill the time. He said every day there used to be a debate. I said, what debate inside the jail? He said, except me, all our 19 convicts were lawyers. They were all into the freedom movement for the cause of the country. It is they who got the freedom for this country. So he said they used to select the subject. One day Transfer of Property Act, section 53A. One day section 113 of the Evidence Act. Like this, and they used to discuss every day. One person used to give a lecture, others used to ask question and answers, they used to interact. And he said, I was the odd man out. So he said, if at all, if our country gets freedom, and if at all, if I get married, and if at all I get a son, I will make him a lawyer. I said, because of the vow you have taken, I should be punished. And somehow he persuaded, then he said, all right, you become a lawyer. If you are not interested in the profession, you leave it, you do whatever you want. I want you to become at least a lawyer for a day. Then I became a lawyer because I was the first lawyer in my entire family, neither from my mother's side, neither from my father's side, there were any lawyers. Why I am telling you is, you need not feel infra-dig or be disheartened, being scared, being withdrawn as to why you chose the profession of a lawyer, that you do not have anyone in the profession. You need not be, because you know what I am today. Only thing, my esteemed brother Justice Jadhav has put it, the 3 I's. And also I'll say 3 H's. Honesty, humbleness, humility. Coupled with hard work, definitely will come up in life. The 7 Saptarishis, they dreamt of something. Could they have imagined that the institution would grow to this stage? They had their future young engineers or young graduates. They had their future at their hands. They sacrificed their life. They did hard work. They built the institution. Whatever the fruits you are enjoying, it is because of the hard work done by the Saptarishis, carried on by Dr. Gore. Such a great institution has been built. Friends, you must be knowing that India had the 2 most powerful universities in the world, Takshashila and Nalanda University. Now you get all answers. You need not even type it. Okay, you can say, Siri, give me this, she will give it. Those days, I am telling you, thousands of years ago, they had entrance test at these 2 universities. What type of entrance test? The gatekeepers used to ask the persons who are coming to the university 5 questions. If they answer 3 questions correctly, they were let in. Just imagine a gatekeeper conducting asking for the question, posing the questions to the student, getting the answer, and the same gatekeeper would not repeat the same question for the next student or for the entire day. Just imagine what is the capacity of that gatekeeper. If that is the capacity of the gatekeeper, imagine the capacity of the teachers who are inside that university. That was our India. It is that you should, and probably, and I wish that KLE University would also one day become a Takshashila or Nalanda University or world famous. See, everyone says, now everyone, you are all budding lawyers. Everyone says, right. No, you start speaking with someone start arguing. They do not know who you are. Immediately they'll ask, are you by any chance lawyer? They say, well, the moment you say, no, we could make out by the way you argued, you are trying to force upon yourself. It is to exercise the right that you are trying to persuade someone. Fine. Article 14, Article 16, Article 19, Article 21, everything agreed. But correspondingly there is what is known as fundamental duties. Article 51A. I have been telling at few forums on this issue also. I think if I am not wrong, I think it is subarticle F or H. Every citizen should strive to achieve excellence in all spheres of life. That is what the subarticle says. How many of you have seen Three Idiots movie? Oh, very good, excellent, excellent. You know what is that hero, Amir Khan, right? He says one punchline. Excellence के पीछे भागो, सक्सेस के पीछे मत भागो. एक्सेलेंस के पीछे भागो तो सक्सेस वही आ जाएगा. Go after excellence. How do you achieve excellence? Number one, respect your teachers. You know why I will tell you? They are called gurus, right? What is guru? Guru is a Sanskrit word. One who takes you from darkness to light is called guru. He or she, the professor or the lecturer or the teacher, strives so hard so that you will achieve something in your life and you will become a good citizen. So, respect your teachers. 2, respect your parents. Take care of your parents. Don't think of putting them into the old age homes. That is not the place where they should stay. You may give them 7-star infrastructure, but that is not the one. In the evening when you come back and you talk to your father or mother holding their hands, how are you, how did you spend your day, will wipe out all their tears and all their sorrows. It is your love and affection that is required. Respect your parents and respect your country. That is why in Ramayana, when Rama wins and they would be celebrating, Vibhishna will come and say, brother, now that we have conquered, Bhabiji is also here, we will get Bharata and Shatrughna here and let us start doing administering our kingdom from here itself. Because Ravana would have the best palace, it was a golden palace. So they will say, we will stay here. At that time Rama will say one thing. What does he say? Janani janmabhumischa swargadapi gariyasi. Janani janmabhumischa. Mother and motherland. Swargadapi gariyasi. Both are above even heaven. So don't forget, whatever you will be in your future and whatever you are today, both your physical existence and your professional existence, you owe it to your parents. So don't forget them. This is why sometimes I get some wild ideas and my wife will be shouting at me. It's not normal. So one day I told my wife that today, day after tomorrow, we will be going to some place. She said, where? I said, I also don't know. So then she said, what is this? You are speaking like something, you are out of your brains or nuts. What is this? Then I said, I had a teacher by name Y.N. Ramesh. I want to go and felicitate him. I said, where is he? What is he? I said, I have lost touch with him from 37 years. So I said, by tomorrow I will search for him. So because I was a judge by that time already, so I put my protocol people on job. Somehow through the police station, they found out where he was staying. Luckily he was in Bangalore. So why I selected day after tomorrow on that day was, because that was the day of Guru Purnima. So I said the best way to pay respects to my teacher is to go to his house, talk few words, touch his feet, take his blessings and come back. Unfortunately, it so happened, the police people, local police people, they visited him 3-4 times from morning. He was so scared. Why police people are coming to my house? So the moment I entered with my gunman and also the local police, he thought now they have come to arrest me. So then I said, he couldn't recognize me. I was meeting him after 35 years. So myself and my wife went, we just offered him fruits and flowers. I touched his feet, he was so happy, he hugged me and cried. Keep in touch with your teachers, because whatever you will be in future, they are responsible for you. They have worked so hard. That is one aspect. And hard work, I said. There is no shortcut to success. As mooters, probably because I did not, normally when I attend the moot court competition, either valedictory or inaugural, I will be knowing what is the moot court, this thing. You know, this, you have this, I think, surrogacy law today. Surrogacy law is now, which is that enactment which has come, including, I think, that prohibition of sex determination also is one of the enactment. Determination of sex is prohibited. This you are thinking of now. 6,000 years back, this has been done. If you go to Krishna Yajurveda in Sanskrit, it is Krishna Yajurveda is one of the 4 Vedas of Samaveda, Yajurveda, Atharvana Veda, Krishna Yajurveda. In that, you get what is known as Aruna Prashnaha, that is question and answers with regard to the sunlight. There, you get subject to correction, I think somewhere around 39 or 38th stanza or verse. It is called Apakramakaha mantra. Tayo reto vatso ahoratrihi. Everything is explained. What should be the progeny? What should happen in case of surrogacy? How it is done? Why it is done? How it is taken care of? Everything is explained. Now that is codified as law. That is why it is said, a law cannot become a common sense. Law is crystallized common sense. Law is nothing but a crystallized common sense. We have that rich culture. So you should study. Lawyers, as my brother has put it, your job is not only to study the law books. You know why the lawyers are called as learned? Because you know something of everything. I will just give one small example before I will conclude it in another 4.5 minutes. In one matter before me regarding patents, top lawyers of the country, when I was in Karnataka High Court, they came. They were arguing. Oh, all Halsbury's of law, Halsbury's law, English law, Australian law, everything. It is only passing of action with regard to, BD, that smoking BDs. I casually asked, Mr. Counsel, you are arguing for a case for passing off. One was trying to sell the same product as though that is the original product of so-and-so. So his case is the customer will get confused and he will buy his product, so it would hit my sales. So he is passing off his product as my product, injunct him. So I asked him, Mr. Counsel, can you please tell me how many BDs are there in one packet. He said, your lordship wants to know how many BDs? He said, I don't smoke, my lord. I said, did I ask you that you should smoke? I asked you how many BDs are there? Oh, 1 second, he asked, instructing counsel, Mr. Counsel, how much? He said, I don't know. He asked his another counsel. He also said he doesn't know. Then he said, counsel, I said, all right, what about the other side? The other side also did not know. I said, because passing of action is the common man gets deceived. A smoker, BD smoker, he says, I want particular BD. So if this BD is given, he takes that as that BD and smokes. He will not know because he is a gullible person, not with worldly knowledge. So the chances of getting deceived or being taken for a ride was more. I said, even an illiterate man who takes that BD, the moment he touches the packet, he will know this does not contain. I said, what you are selling contains 60 BDs, what he is selling contains 50 BDs. So the moment you touch the packet, you will know which it contains less BDs. The reason why I tell you is, you should know something of everything. Then you don't tell me that tomorrow, sir, I wanted to argue a case of liquor, so I wanted to consume the liquor. They never ever do that. Because you told, one Supreme Court judge had said, that is why I am doing it, don't repeat that. You should study, you should have in-depth knowledge of everything. Suppose you argue a case for trademark or copyright of a song. You should know the raga and tala. You conduct a case relating to the damages of a construction. You should know what proportion the cement and sand is mixed, what type of iron steel is used, 18 mm or 22 mm, what is the depth, what is the structural, you should know structural engineering. Suppose you conduct a case for motor vehicle damages, accidental injuries suffered and he asks for damages. One lawyer was arguing before our court. I was sitting in a bench, said, my lords, it's simple case, my lords, mandible fracture. So they are given only 2,000 rupees, kindly enhance it to 6,000. I said, all right. Mr. Counsel, let me understand, where is this mandible bone? Mandible bone, my lord, here. Here, my lord. Oh, both sides? Oh, yes, my lord. He was so thorough in asserting what he was telling the white lie. I said, Mr. Counsel, we will give you the human chart. You please look into it and tell us. Then he looked into it and he was a little senior advocate. He said, oh, I got confused, my lord. That's a different issue. He did not know where mandible bone is. Suppose you are conducting a case relating to this motor vehicles, human body damages, or a murder case, or an injury case, or any case relating to the stabbing. You should know the physiology of the body. You should talk to the doctors. You should talk to the engineers. You should talk to the musicians. That is why you should read the books. That is why the lawyers are called as learned is because you know something of everything. That is why you are called as social doctors. To get this, you will have to work hard. You will not get it easily. If you run behind excellence, excellence के पीछे भागो, success वही आ जाएगा. कैसा आ जाएगा? Hard work. That is why I conclude by saying there is one in Subhashita. There is one saying. This is what it says. Artha turanam na guru na bandhu. You know artha means earning money. Artha turanam, the person who is in greed of money. Na guru na bandhu. He doesn't bother about anything. Neither it is Guru. He wants money, that's all. Kshuda Turana na pakva na ruchihi. When you are hungry, normally, everybody, you just think of it. Sometimes you go home, you say, Ma, I am very hungry. She comes and gives something, you take 1 spoon, 2 spoons, you eat. Third spoon you will say, Mama, you forgot to put salt. She will say, no, then she will also taste and say, yes, I am sorry, I forgot. Why did you not say it in the first one and second one? Because you are hungry. Kshuda Purana na pakva na ruchi. You don't think of the taste and anything else. You want to fill up your stomach. Kama Turana na lajja na bhayam. The person who is after lust, he doesn't think of anything else. Last but not the least, which is the most important to you, young students, the budding lawyers, because lawyers continues to study. Vidya Turana na nidra na sukham. If you want to acquire knowledge, no going to bed at 10 o'clock and getting up at 9 o'clock in the morning. No pizzas and no colas. Work hard. You will get good result. Once after 25 years, after this hard work, initially you may not get success. Once you start getting success, then you will say, whatever I am today, it is because of my teachers. It is because of my parents. It is because of my elders. It is because of I was born in this country. Make your country proud, make your institution proud, make your parents proud, and you also be proud of yourself. This all can happen when you work hard. And this is one profession. Now earlier, as my brothers have already put it, that was when we were there, that was the least chosen profession. Honestly, I will tell you, one day, I think somewhere in 2014 or 15, one of my friends said, I put my son to so-and-so institution, and I said, very good, you are making him a lawyer. He said, yes. Then he said, no, I could not get the seat. I had to pay donation. I said, lawyers, to join LLB, I had to pay donation. I was so happy. On the lighter side, in the sense now this legal profession is taken as a serious profession. So not only you should become a hard-working lawyers, you should come to the courts also. Come to the court, be in the battlefield. That is where you enjoy. You will enjoy being in the battlefield, discharging your duties as a lawyer, and particularly, and I suggest every one of you, you would have all been thinking, majority of them I know, you'll be thinking, what do you want to do? Sir, I want to become a judicial officer. What is this? You are now in still final year LLB. Yes, after fifth year I am already preparing. All Moot, what is that, mock courts, mock questions, everything. I am not discouraging that you should not become judicial officers. First you should know the practical, you should have the practical knowledge. In that 4.5 minutes, I think half a minute is left. So I would say why you have to study, because every day is a learning process. If a lawyer says that I know everything, I know the best, that will be the last day for him or her. One small example of myself, I will not give examples of any big names. So let it be reserved for something else. You are all youngsters. Have zeal. Once I was just 2.5 years old in the lawyer profession, I joined my senior office. We were 3 colleagues in the office. Friday evening we wanted to go out for dinner. We had all planned, 3 of us. We will go to such and such a restaurant, we will have dinner, then we will go to such and such a place, have ice cream, and then disperse. We were about to get up at 7:40. My senior said, Arvind, why don't you take out that file? Tuesday that matter is coming up. Said, sir, today it's only Friday. Tuesday we'll look in on Sunday. No. Sunday I have some other commitments. You take out that file. So we looked at each other. We knew that our weekend is spoiled. He took out that book, that file, and that was relating to section 32 of the BDA Act. It is Bangalore Development Authority Act, relating to bulk allotment. 32 or 38, I think. Bulk allotment. So he said, read that section. We came to the conclusion that our dinner is gone. No other option. We cannot say no to the senior. So we sat. He took out that book and he said, read that section. I was reading so and so, so and so, so and so. He said, no, don't read it fast. Read it slow. So I started reading. He said, I think there must be some punctuation, he asked. I said, yes, sir, there is a comma. That section read, notwithstanding anything contained under the Act, the authority has got the power to lease, sell, comma, otherwise deal with the property so vested in it. You must be wondering, what is this you are reading section 38 of BDA Act? Because I had read 1,000 times, more than 1,000 times. So I said, sir, how many times whatever you read, it gives the same meaning. He said, no, I did not concentrate on this comma. Why that comma is put? I was so upset with my senior. I said, sir, the draftsman did not have time, so he just put a punctuation. He said, no, it's not like that. Take out GP Singh interpretation of statutes. Then he said, take out Halsbury's Law of England. Take out that, take out this, Trout's Law Dictionary, Black's Law Dictionary. Explain what is comma. He said, then it was already 11 o'clock. He said, all right, you take this file, study, and let me know a day after tomorrow. So next day I had to go and sit in the library. We did not have the benefit of this laptops and iPads at that time. So we had to physically search in the books. So I went with my colleagues. We sat in the library, all the three of us. We got, and then we found out on comma, punctuation of comma, there were more than 400 judgments of various high courts. And what we read on that day is helping me today in discharging my judicial function. Why I said is hard work. That 3 hours on that day. Suppose had I told my senior, sir, no sir, sorry, we are going out, he would have not said anything. It was we who would have lost. So I do not want any one of you to lose anything in life. You should not repent. That is why the luck is defined by Aparesh Acharya, is that center point of life where opportunities passes by. If you are intelligent, if your attitude is capable of grabbing it, you will say good luck. If you are otherwise, you will say bad luck. So both are in your hands. Take care of yourself, take care of your parents, take care of your teachers, respect your institution, and give back to the institution what you got from the institution. With this, I take leave of you. May God bless every one of you. And last but not the least, the great institution which is pioneered by Dr. Kore, I hope and trust that this will gain international recognition, which it has already gained in the medical field, and in every field, and in law also it will gain this level at the international level. And I hope after my retirement, one of those days, I will come as a judge to judge the international moot court competition. All the very best.
Thank you so much, Lordship, for such interesting insights and motivating our students. It was truly inspiring. Thank you once again. And now for the moment that we've all been waiting for, the prize distribution ceremony. The participants have demonstrated remarkable legal aptitude and advocacy skills over the past few days. This is a moment to honor the hard work and present them with the success. We would begin with the prize distribution ceremony for the client counseling competition. The first award that we will be distributing today is that of the Best Counselor. This award is presented to the team NCC 01, IILM University, Gurugram, and the award goes to both the counselors, Counselor 1 and Counselor 2, Kashish Khanna and Shrubi Gupta. I will now request Honorable Justice Shri Milind Jadhav, Judge High Court of Bombay, to give them the award. Congratulations team. The team is receiving a trophy and cash prize of ₹3,000. Moving on to the much awaited award in the client counseling competition. I'm going to be announcing the winner of client counseling competition, and I will request Honorable Mr. Justice Arvind Kumar and all the dignitaries on stage to present the award to NCC 07 Damodaram Sanjeevaya National Law University, DSNLU, Visakhapatnam. The team is receiving a trophy and cash prize of ₹11,000. Hearty congratulations to the winners. The runner-up of the client counseling competition is NCC 01 IILM University, Gurugram. I would now request Justice P.S. Dinesh Kumar to felicitate the participants. The team is receiving a trophy and cash prize of ₹5,000. Congratulations. Now moving on to the moot court competition. We will begin with the Best Student Advocate Award. The Best Student Advocate Award goes to NMCC 08, the Speaker 1 from Christ University, Lavasa. I would now request Honorable Justice Milind Jadhav to give the prize. Aishwarya is receiving a cash prize of ₹5,000. The next award is that of the Best Memorial, and it goes to NMCC 04, Faculty of Law, the Maharaja Sahajirao, University of Baroda. I request Justice P.S. Dinesh Kumar and all the dignitaries on stage to present the award. The team is winning a trophy and a cash prize of ₹5,000. Moving on. I will now be announcing the winner of the moot court competition. The winner of the Moot Court competition of Sparkle 6.0 is NMCC 18 KES Shri Jayantilal H. Patil Law College. I would request Honorable Mr. Justice Arvind Kumar and along with the dignitaries on the stage to give the award. The team is KES Shri Jayantilal H. Patil Law College, and they are winning a trophy and a cash prize of rupees 31,000. I now request the dignitaries on the dais to present the award of runners-up of the Moot Court competition to NMCC 22 Alliance University. The team that's winning the runners-up is Alliance University Bangalore, and they are winning a cash prize of rupees 21,000. I request all the dignitaries on the stage to present them with the award. Thank you teams and thank you dignitaries. A big round of applause to all the winners and participants. To conclude this grand event, I now request Professor Dr. Dinkar Gete, Principal, KLE College of Law, Navi Mumbai, to deliver the vote of thanks.
Yeah, I know this is the most difficult part because everybody wants to leave now, that's why you are clapping. I do understand that. But I have to complete the formality, and if I do not complete the formality, I mean you would not be completing this event. So have a patience for 5 to 7 minutes. First of all, I would like to thank Justice Arvind Kumar sir for gracing this occasion. Thank you sir, thank you on behalf of the KLE Society's KLE College of Law that you have graced this occasion. Justice Arvind Kumar sir has told us, respect parents, respect motherland, respect profession, but I will say, as respect teachers, now this is a turn of teachers, I say respect judges. The reason being is they are backbone of the nation and they are protecting our constitutional right. Thank you sir, thank you once again for gracing this occasion. I would like to thank Justice P.S. Dinesh Kumar sir. Last night I received a call from his lordship and he said I would not be making for a lunch, but ensure that when my driver comes, please he should have a food. So see, judges are humans, but I would say judges are more human than us because they undergo a rigorous practice of constitutional principles and all other principles whereby they know the needs of the society and that's how they act. Thank you so much sir for gracing this occasion. I would also like to extend thanks to Justice Milind Jadhav sir. When I entered his chamber, he did not even waste 1 minute. He said, okay, you have preponed your event from 23rd to 22nd. I am going to be there, principal sir, don't worry. A man of few words, straight away he said, I am coming. So thank you so much sir for your... Thank you sir, Dr. Somu CS, Christ University, Lavasa. I mean, he was dean when I was working under him in Christ University, and a very hard taskmaster and a very good teacher as well. I would see him as a symbol of dedication, because he used to come in the morning around 7:30 and go back in the night around 9:30, 10 o'clock. And once or twice I saw dogs would escort him to the gate. There was no one in the campus. He has such kind of a dedication, and he has given almost 15 to 20 years of his life to develop not only Christ School of Law, but also Christ University. Thank you sir, thank you so much for gracing this occasion. Yes. Now, our beloved chairman, Dr. Prabhakar Kore sir. Dr. Prabhakar Kore sir told a story about Saptarishis, how they came to Ferguson and everything. But I would like to say, he is the 8th Rishi. He is the 8th Rishi of KLE. Please give him a big round of applause. He's been chairman for more than 3 decades. The growth of KLE institutes from 35 institutes to 310 institutes was under his visionary leadership. When I met him in the morning, he told me, I am giving you the new building for law college. Now it is your responsibility to make this law college a #1 law college in Mumbai. Sir, we assure you that we would be walking on the path which you have directed us. Thank you so much, sir, for gracing this occasion. Now, as already His Lordship has said about generals, so we take it as a precedent. Our directors who are here, Shri Mahantesh Kaudgimat sir, Shri Jayaman Munawali sir, Shri Shankarana Munawali sir, they are the GB members, and whenever they conduct a GB, last month I went to Belgavi, and Shri Mahantesh Kaudgimat sir told me that I will give me a 1 year's plan, so that what kind of activities you are conducting. So not only chairman sir, but also GB members, and all of them are like, there's a saying in Hindi, you know, छन्नी और हथौड़े से ही मूर्ति बनती है, and that's what they want from all the administrator working for them, that the best for the institute should happen, and that's what their intention is. Thank you sir, thank you so much. My mentor, Dr. Mallikarjunaya sir, he has been in journey with us since last 6 national law competitions, and the journey started, it continues, and will keep on moving, and he is there with us as a shadow for us in this journey, helping with nuances and making this institution to go forward and guiding us. Thank you so much sir for your kind help every time. All the judges judging various rounds, all the participants across the nation, especially I must say, hats off to all the volunteers. Please give them big rounds of applause. This event would not have been successful without them. All the teaching and non-teaching staff, and all the wonderful students, those who are sitting here in this hall from 1 o'clock, kindly clap for yourself. All the technicians and everyone, thank you so much for gracing this occasion. All the dignitaries, all the students and everyone, once again, have a very nice evening. Thank you so much.
request the participating teams to wait for your semi-finals and quarter-final merit certificates.
You distribute the certificates?
Students, you have to give your attendance, so there's no point leaving. Can you go back and sit? Not gonna work. Nope. Attendance चाहिए तो बैठो, जाओ.
अपने स्टूडेंट्स को बोलिए ना बैठने.
बोल रहे. All students at KLE College of Law, kindly be seated. Nobody asked you to leave. If you want attendance, I request you to please be seated for the next 5 minutes.
Please,
Let them sit. It's chaos. Sit, Baba. Kindly settle down and maintain silence. We will be distributing the merit certificates for the quarter-finalists of the Moot Court competition and semi-finalists of the Moot Court competition, and merit certificates for the semi-finalists of the client counseling participants right now. All the winning teams, kindly share your account details to the core committee. All the winning teams, kindly share your account details to the core committee members. Whoever you are in contact with, we will transfer the winning amount to you guys.
sit down. Everyone, please sit down. Please sit down. Please sit down.
Attendance will not be taken for anybody if you're standing. If you're standing, there is no attendance. Kindly go back and sit in your places. I repeat, attendance will not be given if you are standing. Kindly go back and sit in your places. Attendance will be called out. You can present. You can call out present. You can give your attendance, but you will sit down now and be quiet.
Quarter-finalist of Moot Court competition. NMCC 1. Is NMCC 1 here? NMCC 11. NMCC 25. NMCC 9. Ma'am.
Students, would you stop moving around?
NMCC 25.
They left.
NMCC 11 also, no?
Yeah, they left.
Semi-finalist. NMCC 15.
उनको मैम को दे देंगे.
I request the semi-finalists for NCC to be here for the collection of certificates. NCC 12.
मैम ये क्या हो रहा है मैम? अटेंडेंस ले लो पहले. मैम मैं मना कर रही हूँ.
NCC 12. 12. Ma'am. NCC 3. NCC 3. NCC 3. has to go. Are we audible to all of you? सबको सुनाई दे रहा है? सुनाई दे रहा है ना? समझ में नहीं आ रहा होगा। तो जाइए वापस। हम क्लास वाइज बोलेंगे, आप क्लास वाइज आएंगे, लाइन लगा के आएंगे। अभी लाइन लगाइए, लाइन। I need a line now. Very calmly. Maintain some decorum. Please maintain some decorum. Please, please be calm. All the yours be seated. Can you please be seated?